Byron King. I'm one of the attorneys here at South Carolina Association of Realtors. If you have any questions on any legal issues, please call the legal hotline at 803-712-3478. We got some guests here, but first my colleague, Austin Smallwood, please introduce yourself.
I'm Austin with SCR.
And then our special guests from our Grievance Committee and Professional Standards Committee, Realtors James and Mark. James, please introduce yourself.
James Akers, been a realtor for 20 years up in the Greenville area. Been on professional standards for I think 5 or so years.
Welcome.
Thank you.
Mark.
Mark Davis-Cote. I'm primarily down in Beaufort area, and I've been a realtor since 2011, and broker in charge, real estate instructor, and happy to be here talking with y'all.
Yeah, fantastic. Thanks for volunteering on our professional standards and our grievance committee. I guess the first question that people likely will be interested in learning is, I guess we'll reverse order. I'll kind of ping back and forth between you two. Mark, how did you get interested in not joining the association, but getting involved, local associations? What kind of roles you played at the local associations and state?
Yeah, so I'm a broker in charge, and as broker in charge, I've got a bunch of agents, and I want them to have knowledge. So I like to bring back information to to my agents. At the local level, I'm on the Beaufort Jasper County Realtors board. I'm the president in 2025 right now. Professional standards, I've been on it a few years, just like James, and I am the 2025 chair for the Professional Standards Committee as well. So yeah, I just got into it because I wanted to be able to give back, and I wanted to guide my agents on what to do and not to do. So being part of the process helps me be able to do that.
Fantastic. Thanks for serving. James, same question, kind of how you got drawn in to the association, local, state, and roles that you've played.
So currently, I mean, it's the same. You know, as a broker in charge, you don't want to end up on the wrong side of the table. You want to make sure your agents know what to do, how to do it correct. Originally, I worked for Seabrook Marchant in Greenville, and he was chair of the professional standards at the time, and he kind of input that work ethic into us, that make sure you're doing it the right way. And then I kind of joined there, and then moved over to the state before Greenville moved over here, but back then. But yeah, I've always been one of those people who likes to, see standards of practices and stuff like that. So I've always been interested in, making sure that we're doing things the correct way and we're living up to the code of ethics. So that's part of why I wanted to be involved in here.
Thank you.
Part of it too, I guess, for me was like as an instructor too, like, yeah, people who've never been licensed before, and they hear about license law and just kind of the differences there. So that was one of the reasons for sure that I wanted to do grievance and professional standards. Like, there is a difference between license law and the code of ethics.
Sure.
And so being able to talk about that with incoming new licensees, people who are hoping to get their license, kind of laying that out a little bit too for them. It's not technically part of the class necessarily for pre-license, but it definitely gets talked about.
Yeah, super. Yeah, and you guys brought a couple points in, Austin. I'll ask you to kind of follow up on. So what Mark was talking about, the difference between LLR and SCR. What when you get on the hotline, when you get calls and people confuse us with the state government, what can you kind of tell the viewers what the differences are?
Yeah, so the real estate commission is under license law. That covers everyone who has a real estate license, whether they're a member or not. If there's a complaint filed, the real estate commission, that is going to be based on a statutory violation. So you actually have to violate something in Title 40, Chapter 57. Some of that overlaps with the Code of Ethics. Some of it does not. We cannot enforce a statutory violation of the association, and the real estate commission cannot enforce a Code of Ethics violation. Now, there may be a scenario where like I said, it's both. For example, under license law, you have to present all offers and counteroffers. You do as well under Standard Practice 1-6 of the Code of Ethics. So in that case, you could file with both. So generally, when we get that initial call, we ask, what is your complaint about? If it's something that is strictly a statutory violation, failure to provide like an offer rejection form, then that is more of an LR issue. If it's something that's solely in our purview as an ethics complaint, then we'll file it there. If it's a way to do both, then we certainly provide them that information. But the key thing is the governing documents. The governing document for LR is that license law, Title 40, Chapter 57. For us, it's the 17 articles of the Code of Ethics.
Super. And then one thing that James brought up, because he talked about getting started with Seabrook Marchant, Greater Greenville, when they did their ethics. The state, we have a statewide cooperative contract with the local boards. Kind of describe how that operates, how we do statewide professional standards now for all the local boards.
Yeah, so if you want to file a complaint with SCR, that is actually like filing with your local board. So sometimes people are confused and that, hey, my complaint has been appealed up to the state. No, we take the place of the local board. The advantage of us having a cooperative agreement is you don't have anyone locally looking at your complaints. You don't have anyone locally in your ethics hearing, so you don't have to worry about, hey, people locally are going to think that I'm a troublemaker or somebody who likes to just push buttons. You're able to get a more neutral panel because we're pulling from people across the state. It also allows us to get a larger jury pool, for lack of a better term, so you don't have the same 8 or 9 people locally who are having to go to a grievance committee every week, 2 weeks, 3 weeks. If you're on a statewide grievance for professional standards, you may only get called once a year, unless you want to be called more than that. But you'll be called about once a year, depending on when complaints are called or when hearings are scheduled, if you're available, and then also assuming that they're not part of a board that you're a member of.
So going to that point too. So as a board president, talking to my association executive down in Beaufort, Janet Gresham, she lets me know that sometimes people do call the local board, like realtors called to complain about other realtors, and they call that local board, and then sometimes she'll say, hey, talk to the professional standards people, call the legal hotline, right? Talk to you guys about it. Or every now and then she's kicked it over to me a little bit and said, hey, you want to explain the process to them. So I think that's the other reason that that James and I probably got into this, right? I'm not speaking for you, but being able to explain the process to my colleagues.
Yeah, and I think something you said is important too. I have realtors all the time who will say to me, well, that's against the law. And I'm like, no, that's against code of ethics, not against the law. Or that's against code of ethics. Well, no, it's against the law.
Yeah.
The differences in the two and what each mean and how they overlay on each other.
Yeah. And sometimes it's not even a license law or a code of ethics issue. Sometimes it really is maybe a civil or a criminal issue beyond that. So
I got my feelings hurt and didn't like the way they did it.
Or just somebody who's mean to me.
Right.
Yeah.
Right.
Yeah, that is a common one we get, is that there's nothing in our code of ethics that is for being a jerk.
Yeah.
Sometimes there's while it's the professional standards process, there is some stuff that just falls under professionalism that we do not have the ability to police. Neither does the real estate commission. That's usually something that's handled more broker to broker. But just because somebody is acting rudely or inconsiderately, that may not fall under the code of ethics. But the only way for you to figure out whether it does or not is to file the complaint. If you simply call your local board president, your AE, the real estate commission, us, and just constantly once a month or once a year call and complain that so and so is still not being nice to me, we're going to say file a complaint. Because unless and until we file a complaint, there's no determination that can be made. Staff does not have the ability to tell you whether or not an ethics violation occurred. We don't have that ability.
Right.
Neither does your local AE. Neither does your board president. Neither does the professional standards committee chair. Neither does the grievance committee chair. The only people who can determine whether a violation possibly occurred is the 5 members of that grievance committee. And ultimately, whether a violation occurred or not will be the determination of the 5 members of that professional standards panel.
So it's like a jury of my peers, kind of.
Absolutely.
Yeah.
And a lot of times you find out things in the hearing that you didn't read on paper that really do make a difference. I'll read something the night before, the week before, and then get in there and things go completely different to how you thought they might go because you hear something new or something that was left out.
That's been fascinating for me over time. Is you as a panel member, if you do serve on a panel, you see the complaint, and it's hard not to have a preconceived notion, right? It's hard to just read the complaint, but the people get a chance to actually speak their case and to defend themselves. And I'm often surprised at what I thought was going to be the primary problem. It is not when we're actually in the hearings.
Same, or I'll see something and think this will be a really, really quick hearing, and then it's not at all. Or I think this is going to be a really long hearing, and it's not at all.
Yeah.
It is interesting, some of the things we run across.
Yeah, I see you got your CRS pin, your designation pin. Congrats on that. And when you're doing a listing presentation or even a buyer agency presentation, you're selling yourself and being a realtor. What are some ways you tell the public what differentiates realtors from mere licensees?
Well, a lot of times the things that I hear complaints about aren't necessarily legally a problem. People generally obey the law, realtors and licensees. But the things that people have a problem with, I don't think I was treated fairly in this negotiation. I don't think my offer was presented in the right way, or they handled me differently. A lot of those are ethics violations. They're not they're not legal violations. So as a realtor, I have to live up to a higher standard. And agents sometimes will come into my office and they'll say, "Can I do this?" And I'll say, "Well, that's not illegal, but it's unethical. You cannot do that." So we hold ourselves to a higher standard. We look out for the public good to a higher standard, and we hold ourselves to that higher standard. It's part of why we have professional standards. Is we kind of self-police each other, and that's the reason. If you see something, you should let us know about it.
There's an extra layer of accountability.
Yes.
Right.
Yeah.
There's an extra layer of accountability that we as realtors have beyond license law.
Correct.
So when teaching ethics, you have the rules that you have to follow and the rules that you should follow because it makes you better. It's treating others the way you want to be treated. It helps you do unto others the way you want them to do unto you.
Excellent. And Austin, when you teach on your ethics training, your classes, how do you kind of explain, when you're talking about the history of the Code of Ethics, what are some highlights you bring up to the class about why the Code of Ethics is so important for realtors, whatever you bring up during your classes?
Well, typically most folks aren't even aware that the Code of Ethics predates license law. The Code of Ethics, was started in 1913. So it is sort of the basis for license law. So that's where there's a lot of what you see in license law is in the Code of Ethics. But sometimes the Code of Ethics goes beyond it or creates or gives more guidance. Two examples that kind of come to mind would be, in Article 4 of the Code of Ethics, as a realtor member, you have to disclose if you have a personal interest or if you have a family member who has a personal interest. Under license law, you just have to tell if you have an interest. There's nothing in license law about I'm representing my mom, my son, anything like that. But that is an additional point of interest that you would need to disclose as a realtor, and it goes into further explanation in standard practice 4.1 of when you have to do that you have to do it in writing and has to be before the contract is signed. Also, you look at like Article 16, which is the not interfering with the exclusive brokerage relationships. It is in license law that you shouldn't interfere with another brokerage relationship. So whether you're a realtor or not, you can't interfere with your brokerage relationships. But under standard practices of Article 16, it explains, well, what do you do if the client reaches out to you? What do you do if the client has not reached out to you? What do you do if you're in a brokerage and you're about to leave the brokerage? So creates a little, while we both license law and the Code of Ethics start with the same premise that you're not going to interfere with brokerage relationships, license law sort of ends at that point. You shall not do this. The Code of Ethics provides a little bit more explanation. Here's the way that if you're going to do it, here's when you wouldn't be violating it. Here's when you would be violating it. Here's the way to do it professionally. Here's the way to do it unprofessionally.
I like that point, the standards of practice. There's no standards of practice inside of license law. It just doesn't exist, right? Correct. So even though Article 4 or Article 6, whatever it is, is the code, the standards of practice really dig deeper and give examples that the panel members then can consider of, as they help make that decision as to the complaint.
Right. And the Code of Ethics changes. We look at it, we adapt with technology and stuff like that. License law does too. It's just much slower.
Yes. It is much easier to change a Code of Ethics, part of the Code of Ethics, than it is to go through the legislature.
To get the General Assembly to actually
Yeah.
So
great new license law. Congratulations last year on getting that done.
Yes.
Like that was getting license law changes. That was good.
Yeah, and then kind of shifting gears a little bit, some of the viewers of this video would be our grievance committee members. So we do everything by Zoom now for grievance committee. It takes roughly about an hour. We'll have 1 to 4 cases. Lindsay Pittman is our administrator. She'll coordinate with grievance committee members who are realtors and select a group to come on the grievance committee. And so for you two gentlemen, if you were giving advice to a grievance committee, what are some things that you want to say? You're going to chair the grievance committee. What are some things you say to your grievance committee to kind of let them know, hey, here's what we're going to do today. Here's our agenda. What's kind of your process? What are some thoughts you want to share with grievance committee members?
I'm going to let you do this because
Okay.
you've actually been on more grievance than I have recently.
I would say, first off, engage. Read the case the night before, the cases the night before, and then be engaging, ask questions. But you're not there to try the case. You're there to assume that if things happened as alleged, would this be a violation and should it be passed on to professional standards? A lot of times in grievance, we kind of come in wanting to know, questions, details that aren't pertinent, and then we want to know what happens, and you don't actually find out what happens. You make a decision. If it moves on to the next step, that's where it ends for you. But it's grievance should be pretty cut and dry, pretty quick. Here's what's alleged. If this is accurate, is this a violation? And if so, it moves on. If not, it doesn't. It's pretty cut and dry with grievance.
I mean, just the timeline on grievance. So if somebody has a complaint against somebody else, there's all kinds of things they can do. If you feel like somebody's harmed you or harmed your client, your customer, then there's all kinds of things you can do. You could reach out to mediation first. You could talk to an ombudsman. You could file the complaint, and then the grievance panel looks at it and decides if it has merit to move it to the professional standards hearing. So there's several different options to the process of how it could go.
Exactly. And Austin, you said you're board counsel a lot for grievance committees. So explain the board counsel role on a grievance committee. What's your role when you're on those Zooms with the realtors?
Yeah, absolutely. We'll certainly get to that. I do want to add one corollary to James's role of making sure that you read everything the night before when you are on a panel. The first is read through it, and if you notice that there's a conflict of interest, either the party or a similar situation had to happen to you and you just can't get over it and you know that you will be biased, just let us know. All you have to do is send an email and just say, hey, I won't be available for this call, or I have an issue with case number 3, so can we move that in the order, and I will leave, and at that point, we can certainly handle it that way. When to tell us you had a problem with the case is not after you've reviewed it, it's beforehand. There will be no you won't be put on a blacklist or anything like that for doing that. The second is you need to read the case, and only the case. Do not do any outside research. Do not go look up the parties on Facebook. Do not go look up the property on the MLS. Do not go look it up on any other website. Do not do any of your research. The complainant's job is to prove their case through a grievance committee. You're to take their complaint as they submitted to you on face value and assume, based on everything they told you is true, doesn't move forward. It is not your job to supplement their case. If they need additional information, you can request that as a panel member, but you should not bring that into that matter. So as board counsel at that hearing, my job is mostly to make sure that the rules are followed, that, hey, we're following through. If there's explanations from the questions from the panel of, hey, can we ask for this? Can we ask for more information? What's the problem with asking for more information? Can we add an article? What's the pros and cons of adding an article? What's the pros and cons of adding a party? Certainly there to explain that. Staff does not get a vote. If you ask staff, well, do you think this should move forward? We're not going to answer that question for you. But hey, what would this be appropriate here? We want more information. You can't just say we need more information. You have to be very specific, because the whole part of our process is due diligence or due process. We want to have both parties feel like it was a fair process. If we go back to a complainant and say, we think your best case would be adding these 6 things, that's not very fair to the respondent should one appear and it gets moved forward. So it has to be very specific. And I always tell parties, I'm sure both of you have heard that, is, I would like to know this is not the standard. It's, I cannot make a determination without this document. Your complaint is that I interfere with your client and you didn't submit with us an agency agreement. Well, we don't know that you have a client unless and until you submit us an agency agreement. So an agency agreement would be critical.
That's what proves that it's a client. Yeah.
That would be the critical thing there.
Yeah.
Well, I would like to see the MLS listing. You don't need the MLS listing. So we're not going to ask for that, because we're not going to just say, give us additional information. We're not going to give you a second bite of the apple. It's information that's specifically needed so the panel can make a determination. If that's a determination made by the panel, we send it back to the complainant saying that the panel has asked for the following information. You have 14 days typically to give it to us. And if they don't, then we go back to the panel and say, you got to make a determination based on what's submitted.
Yeah, good stuff. So we get a written complaint, it has to be in writing. We typically get an email. A lot of times we'll get a hotline call and we'll suggest that they can file a complaint. So we'll get the complaint, and then Lindsay Pittman will eventually schedule that complaint for the grievance committee. And she's looking for, obvious conflicts like same town, same franchise. But like Austin was talking about, if you're on the grievance committee and you see it's your cousin, you want to bring that up, or something that's not obvious to us, or you're a partner in investment properties with this person. But the grievance committee is kind of our first gatekeeper. What they do, they'll take the complaint, they'll be scheduled for a Zoom hearing. The grievance committee, they're all realtors without conflicts of interest, like Austin was talking about. We'll do a Zoom. They'll all come in at the appointed time. They'll have the materials ahead of time. Lindsay Pittman sends the materials ahead of time. Like Austin said, read the materials, get familiar with it ahead of time, but don't do your own research. You're not a private investigator. You just stay in with what we send you. And then we'll go through a checklist. We're basically looking for, are there realtors? Was it filed within kind of the 180 days kind of statute of limitations? Does it fit into a code of ethics? Could it go into a citation, which we'll talk about citations later? And then also kind of you mentioned it, but kind of expand on when you're talking about, what do you say when, say, these two gentlemen are on your grievance committee and they want to add an article? What are some considerations you bring up for the grievance committee before they add an article?
Yeah, so we try to make the complaint stand on its own. If you add an article, it actually has to go back to the complainant for review. And the complainant may not have added an article for a specific reason. They may not have added a party for a specific reason. We've had it before where the panel goes, well, the buyer's agent and the listing agent were equally at fault here. Why did they only name the buyer's agent? And so the panel is asked to add the listing agent, and then they go, well, you don't know what you don't know is the listing agent is my best friend. Yes, I understand that they did wrong, but I'm not filing against my best friend. And once the panel has amended that agreement, the complainant has to agree to it or the complaint is dismissed. So generally we try to say, let the complaint stand on its own unless it's a glaring oversight. We try to understand that most parties have not filed complaints before, so they are not, experts on this code. But I've got to say, it's got to be a direct hit, not, well, maybe this or maybe there's some overlap. It's got to be that it's a glaring oversight. They write in their complaint 8 different times, and I asked to speak to an attorney and was denied the right to speak to an attorney. Was told multiple times they didn't need an attorney, but they didn't allege Article 13. You can go, okay, that's a direct oversight. But if it's going, well, maybe, if the second somebody says the word maybe, there shouldn't be an article added. It should be that's an obvious oversight by the party, and the panel goes back to them and says, I think you missed this. But ultimately, the complainant has to agree to it, or it's dropped.
Or the whole thing is dropped at that point.
Correct. And then it has to go back to the Greens Committee to determine if they want to take over it for public trust reasons. But that's going to usually mean that if it meets that high bar, now the Greens Committee has to do a case themselves for a complaint that they weren't involved in. And generally at that point, the complainant's not really willing to assist you. So it's kind of an uphill battle. So you may have taken a complainant that actually wanted to file a complaint on something, but because of your infinite wisdom, you have now morphed their complaint into something they don't want to do and deprive them of the right to seek retribution.
Well, and if it makes it past grievance to professional standards, the complainant's the one that has to argue the case. And
Correct.
If they don't understand what the article was to begin with, grievance isn't going to go into a room with them and explain that article and say, this is why you should have added it. So
1,000%. Yeah, there's not an explainer. If you added in that example, you added Article 13, it doesn't go to them and says the panel's added Article 13 for the following reasons. It just says the panel has added Article 13. You got to figure out why.
you gotta prosecute
Maybe
that
the
case.
complainant has to figure out
right.
how to prove that article that I didn't understand to begin with.
Correct.
Yeah.
And then kind of the flip side of that, an easier answer, the grievance committee, say you have a complaint and they throw the kitchen sink in, they write articles 1 through 17 on there. And so the grievance committee wants to delete articles. Austin, kind of talk about how the grievance committee can delete articles from the complaint.
Yeah, so in that case, we would take the Greens Committee would go through each individual article on its own. We would read out what the article is and look at the statutory, the elements of it, and say, take the complaint at its most face value. I always kind of say, look at the complaint and assume that we send it to the respondent, and the only response we got back from the respondent was no lies, 100% guilty as charged. Would it meet up with that standard? And then it's going to just be a vote for each of them. It's a majority vote, so it doesn't have to be unanimous, but we're going to have discussion until there are 3 votes that article should stay or that article should be removed.
I would say I see that more often on grievance. I see it far more likely that somebody will come in with, 17 cases and then we'll drop it down to 6, opposed to come in with 6 and we had to.
And on the professional standards side, when I'm selected to be on a panel for that. Regularly, we see the original complaint, but then it'll tell us, the only articles, number 13 got dropped, or whatever it was, and they'll let us know, like, hey, here's the only things you're hearing today.
Yeah, and once it's dropped, that's it. The panel, they do have the ability to appeal, but if it gets to a professional standards committee and it started out with 5 articles and it's down to 2, the panel is only discussing the 2. If one of the parties tries to bring up one of the other 3, that can be certainly ruled out of order, as we are only here for the 2 articles that have been named.
What if a realtor has filed a complaint and grievance has shot it down? Can the realtor resubmit with different articles or different evidence?
So you cannot submit the same complaint twice.
Okay.
Article 14.
Double jeopardy clause.
Yes, well,
basically.
and Article 14 gets into filing frivolous complaints. That would get into sort of the frivolous complaint.
Yeah.
Now, it would be an uphill battle if it's the same transaction or occurrence, but you would have to essentially show, hey, when I filed this, I thought it was this problem.
Yeah.
And since then, it's been something else.
Well, and you also have the 180-day window.
Correct.
So you have the time frame too that
Yeah.
that they have to meet anyway. Yeah.
Yeah, I mean, so I'm trying to think of one off the top of my head. So you got a complaint where it was initially filed between a buyer's agent and a listing broker, and the buyer's agent alleged that the listing broker didn't disclose something. It was dismissed because they didn't prove it at that case. But then later on, that same listing, the buyer files against that listing broker because now that listing broker has been saying things about the buyer's business practices, and it's an Article 15 complaint. That previous dismissal on Article 2 wouldn't nullify the ability to file Article 15.
Right.
But if you tried to file an Article 1 saying, well, they weren't honest, which is really a derivation of the same original Article 2 complaint of not disclosing, then that would be probably superfluous and wouldn't be allowed.
And I should mention, there are certain cases where you can file after 180 days if you can kind of prove that you didn't know about the violation.
So the 180 days it's based on when the knowledge is
Correct.
when you have the knowledge. It's either when it happened or when you had the knowledge that it happened, right?
Yeah, it's 180 days from when the events occurred, or a reasonable person would have known the events
Yeah.
occurred. We certainly give usually some deference for, we were in, for example, Mark mentioned mediation. If the party's been trying to mediate this for 6 or 8 months,
Right.
and then the mediation is unsuccessful, and then they file a complaint, we're not going to harm you for having tried to mediate it. We're going to count it from essentially, hey, mediation in July. Okay, you've essentially got through the end of the year to file that ethics complaint. Or we were involved in litigation. Well, we waited until the litigation was over. But if it's, hey, this, our agent wasn't nice to us, wasn't honest with us. We forgot about it until we drove by a neighborhood 2 weeks ago and saw their yard sign, and it made us angry about what happened in 2021. That's not going to be something that we can follow, that we can move forward.
I've heard of basically the same issue several times now, where on the disclosure they said that it was a public sewer, and then come to find out it's septic, and so the buyer buys the property and didn't know that it was septic, and so they never pumped the thing, and now there's backflow and whatever else happens, and so they're not getting to the event until well after the 180 days, so they didn't actually discover it until way into the future. Yeah.
And an example like that may actually prove the difference between grievance committee and professional standards. So if you were to file that complaint, say against me, that says, I bought this house, Austin had the listing, he said it was city, it ended up being septic, and you filed a complaint against me, for it to move forward on grievance, you would just need to have, again, we have to take your complaint at face value. You would just write your complaint saying, Austin failed to disclose to me that it was septic instead of city. Here's where he put on the MLS that it was city.
Yeah.
Here's where he did this and that. That's probably enough to move it forward on grievance. Now, if it goes forward to hearing, I'm going to be able to bring in testimony going, here's where I asked my seller. My seller filled out the seller disclosure. I didn't fill out the seller disclosure. Here's where the seller told me I had no reason to know that this wasn't some rural piece of pasture land 30 miles from civilization. This isn't a residential neighborhood. A reasonable person wouldn't have known that there were issues here. I did the best of my knowledge. I didn't conceal, exaggerate, or misrepresent the pertinent fact to the best of my knowledge. So there's the difference. So the grievance committee just has to take that complaint on face value. The professional standards committee is going to actually elicit a response from the respondent hear them out, hear the complainant out, and then ultimately make a determination.
At that point, it might not be between realtors even. Like it might just be between the buyer and the seller, right? Who are not licensees, probably not realtors.
Absolutely.
And then that's a court thing. That's not even us.
Right.
That's not even. It's not licensed law, and it's not professional standards.
And that's one of the more common ones we see is a complaint is filed, and that maybe is the initial call. Well, I have a complaint filed because there was an incorrect proper seller disclosure filled out. I go, well, for us or for the real estate commission, you're gonna have to show that the licensee knew that and intentionally aided in the failure to disclosure or misrepresentation. If it's the seller lied to everybody, then there's civil penalties allowed for that, and the form for actual damages, court costs, and attorney's fees the buyer can sue through or get through court.
Yep.
Yeah, so you guys are kind of overall talking about kind of due process, and due process is fairness in a sense. It's making sure people have notice of issues, they have time to prepare, they can hire an attorney, there's no conflict of interest, and it also includes the right of appeal. So in a grievance committee, adding, deleting articles or kicking it out for being over 180 days or not fitting into an article, there's an appeal process for the person that wants to appeal that. And that thing about sewer septic, that's probably a good example because it hits a lot of them. It talks about the difference between LLR, SCR, realtor ethics, and even lawsuits. So, and that could be even an example of the 180 days. So say they, everything's working fine for 2 years, and then they have a backup. They might even been paying sewer bills on the hotline. I've heard about when they lay the sewer line, they're billing. So there might even be a bill every month that they're paying. So they just assumed it. But when it backs up and the plumber comes out, they discover, hey, it's not even connected to the septic out in the front. To the sewer line in the front yard. It's connected to septic. So that could be a reason it went over the 180 days. So they would hopefully explain that to the grievance committee because they're looking at that 180-day statute of limitations. And then we'll put things in abeyance sometimes for LLR or for a lawsuit. Also, I'm going to talk about when we put things, say grievance committee forwards this complaint, this sewer septic complaint forward, and they've also checked on her complaint because it says, hey, are you filing at LLR? They check yes. Is there a lawsuit? Yes, I'm suing the seller for misrepresentation. Why do we use abeyance, and what is abeyance? I guess is a good way to put it.
Yeah, so we have a one-page complaint form. So for everyone who's worried about filing a complaint because it's this arduous process, it's a one-page complaint form. I think it's 5 questions. 3 of them are check boxes. And a couple of those questions are, have you also filed this with a court or a regulatory body? If so, when and which court? And have you also filed this with another board? So what you can't do is be a member of South Carolina and North Carolina and file a complaint at both boards on the same complaint. You can file with either, assuming the respondent is a member of both, but you can only do one. The reason we have abeyance process is we will still proceed with your complaint, even if you check yes on all those. We'll still move forward to Greens Committee so we can get that reviewed. So if the complaint is without merit or doesn't match up, then we just dismiss it. But if we decide it does, we'll then reach out to you and say, hey, you've marked that you have filed a complaint with LR, or you have the thing in circuit court, or you have also filed with the, this person's also a builder. You've also filed with the Builders Commission. So we're going to put this in abeyance, which means we're going to put it on pause until all those other matters are resolved, because we essentially are going to come last in that process. Our process is not governed by the technical rule of evidence that may apply in courts. So we allow things such as hearsay, which would never be allowed at a real estate commission hearing, and certainly not at a court proceeding. So we have to go last in that process. We also try to honor the confidentiality of our process. It's really hard to have a confidential process if you will then use the testimony that was elicited in our hearing at a subsequent hearing, especially one of public record. So abeyance does not mean that we have made a determination. It does not mean that your complaint is going to be dismissed. It doesn't mean that you're going to win. It doesn't mean you're going to lose. It doesn't mean the hearing panel has not even been impaneled on that complaint. It is simply a pause until everything else has been sorted out. And just because you've been found in violation at the real estate commission or at a court does not mean that you're going to be found in violation of our process, because again, there's different rules. You may have violated a statutory violation, but not a code of ethics violation. And just because you were found innocent by one of those bodies also does not mean that you will automatically be found innocent at us, because there are different governing documents.
So then we're way past the 180 days, right? Because they went to court or they went to And so then we're way past the 180 days. You mentioned appeals before, Byron. Can people appeal the grievance panel decision?
And I did want to correct on the 180-day issue. So 180-day issues for your initial filing. So think of it like when you go to the Registry of Deeds office, you file a complaint with us, it is actually time stamped, and your 180 days is locked in at the time of receipt. So if you file your complaint 150 days after it occurs, but because of abeyance, it takes 2 years to get to the hearing, that does not, you've met that initial 180-day threshold at grievance. We'll never have a timeliness discussion again.
And the whole reason for this, and also talk about the history of the code of ethics back in the day, there were people doing, bad stuff in real estate, trying to clean up. So our number one goal is to raise professionalism. We're not trying to stop people from earning a living. The number one, on all our surveys, people complain about, hey, my number one goal about working in real estate is the lack of professionalism. So this whole system is to try to get professionalism into our industry. That can be talking to a colleague when you see something, say something like you guys were talking about, talking to their broker in charge, get the brokers in charge involved, to try to handle it at the lowest level. Because the last thing we want to do is have a full formal hearing when the discipline can be very high. We've got a maximum of $15,000 fine. Nobody wants that. So some of the things that we've done on our complaint form, we added language about, do you want to use ombudsman? Because ombudsman gives us additional ways to solve a problem with apologies or money. Also, got to talk about our ombuds program, please.
Yeah, so the ombudsman is mediation that's halfway through. So there are remedies that you may be seeking that aren't available through our ethics process. Our ethics panels cannot mandate an apology. They cannot mandate that you continue to do work together. They can't do anything of that sort. Now we can't. This is a common misconception. We cannot award monetary damages. We can assess fines, which are different than monetary damages. So if you file a complaint and go, you didn't tell me about the septic system, and Marcos also didn't tell me about the septic system. I had to have somebody come out and drain my septic tank, and it cost me X number of dollars. Even if that is 100% true, the hearing panel cannot say, Austin, you need to pay Mark back for that inspection.
We could give a $15,000 fine.
Correct.
And that is not going to fix the situation at
Correct.
all. It's just a fine against the person who did a bad thing.
Correct. That goes to SCR. That money does not, Mark gets exactly 0% of that money. So if all Mark's end goal is, hey, I just want to be paid back, that is where mediation can come in. Mediation is where you and I can get in the room with a mediator, like James, who says, what's going on here? And we'll probably ask me, Mark, what is your end goal? What do you really want out of this? And Mark will say, well, I want to be made whole. There's no ability from our process to make you whole. If your goal is, hey, all I want is Austin to admit that he messed up. I want an apology and a check. And I go, oh, well, I didn't realize I did anything wrong. I apologize. I'm sorry. And I didn't know either. So maybe we can negotiate instead of how about I split the payment with you? And that type of stuff we can do in mediation. We cannot do any of that through our ethics process. So that's the advantage of mediation. So a lot of times, if all you're looking for is an apology, better business relationship, monetary, that type of stuff is where mediation can play a part. If you try to mediate it and it's unsuccessful, whatever you discuss during mediation is inadmissible in the hearing. So there's really no downside to the mediation. The mediation, is, if you do it through our ethics process, we don't charge you. So it's free. It does not prevent the hearing from ultimately being scheduled if there is unsuccessful mediation. Whatever you discuss in mediation is confidential. The mediator will not be on that hearing panel. And it ultimately gives you the ability to figure out some remedies that we don't have available through our ethics process.
Is there a separate training process for mediators and ombudsman that you have to sign up for?
Yes, we have typically annual ethics mediation and normal mediation training that occurs in the fall.
Yeah, because you guys are, James and Mark, you guys are running a business, right? So you want customers and consumers and clients to be happy. So, probably a lot of realtors have bought that refrigerator or done something to make it right. So this ombudsman, even that sewer septic issue, you might say, look, I didn't know about it. I didn't do anything wrong, but I want to make this right. We're, mediating this so you don't file against me. How about I pay, X amount of dollars toward a tap to that sewer line? So that might be a solution that everybody goes away happy, right? The realtor doesn't have to go in and face the hearing. The consumer might even be so appreciative they use you on future business or give you a referral. So one thing we've been trying to push for ombudsman, because a lot of times we'll find out sometimes these parties, the complainant and respondent haven't even spoken with each other. So maybe this is one more way to get somebody to pick up that phone and talk to each other. Because when you're sitting across from each other and talking to each other, we're all humans, we're all in business. Everybody wants everybody to go away fairly happy in a hearing. Somebody's going to be happy and somebody's going to be very unhappy. So ombudsman ethics mediation is a way for everybody to get something and go away pleased. And you guys great job talking about the different alternatives, money to solve a problem, or like Austin about, sometimes people just want to be heard and somebody say, I'm sorry, I didn't realize that I did that to you. So the other way.
With the mediation thing too, it can be a less time consuming endeavor, right? So you have one mediator and then the two parties maybe, and I don't know, maybe they bring a witness or maybe they don't. But when we do the grievance panel, you've got, like Austin said, you have 5 realtors volunteering their time, taking it away from their other business to help create this professionalism, right? And so that's a bunch of time right there. It's staff time. You have to have an attorney in the room, somebody recording it and everything, and recording the notes secretary and everything. And then if it gets past that, of course, then the professional standards, now again, you've got 5 different people. So now we've hit 10 different realtors who all know about the situation. And it could be 15 minutes or it could be 5 hours to go through a hearing. And so the mediation really can be a good process for people to try to nip it in the bud, solve it early on in the process.
Yeah, definitely. So if you're filling out your complaint, you're watching this, try to get some information about filling your complaint. You get that question, do I want to use ombudsman, which is kind of ethics mediation? Please check yes. That's basically what we're trying to tell you guys. The other way we try to save, and Mark talked about it, the 5 realtors on grievance, their time prepping, and then the Zoom, the 5 realtors in the hearing, and then if you throw an appeal board of directors, 5 on each of those, plus staff time, plus risk the association, because if we don't do something right, violate somebody's due process, we might get sued. And we don't want members upset at us because we work for the members.
And then executive committee too, because the executive committee for SCR,
and they ratify
ratifies that hearing and everything. So you've had a lot of different realtors involved in a professional standards hearing that goes all the way through.
Exactly, and I like your phrase, nip it in the bud. Like Barney Fife used to say on Andy Griffith's show, just nip it in the bud. Everybody's happy. In that septic system, somebody got some money to hook into the septic. They're happy. The realtor didn't go through that. The association's happy. We didn't have all this effort going through. So please check yes on ombudsman if possible. It's a great program, but we still get some no's on there. We're trying to turn that around. So that's part of why we're making this video. The other way we try to go all that effort with the hearing, grievance, and all is the citation policy. Austin, when you're on the grievance committee and you're talking to the grievance committee about citations, how do you explain that to the grievance committee?
Yeah, so citation policy is something that's maybe 7-8 years old. Came from NAR to try to eliminate some of every complaint having to go to a hearing. So it's NAR created a model schedule of sort of what I call, lack of a better term, the misdemeanors, the lesser offenses in the Code of Ethics, and said that as a board, you can create a model schedule that says, in lieu of going to a hearing, somebody, if they are found in, if they agree to plead guilty to these standards of practice or these articles, they can be assessed a fine and education in lieu of going forward. I'll give a couple examples of what's in there and what's not in there. So standard practice 1-6, which says you must submit all offers and counteroffers objectively and as quickly as possible. That is in there. So you believe it's a $350 fine and 4 hours of education. If you had a complaint filed against you and you go, yep, I actually did violate that, but the reason is I went to, it was the person faxed the offer to me instead of emailing it to me, and I forgot to check check the tray of my fax machine before I left the office for the weekend. So they faxed it Friday afternoon. I didn't see the offer till Monday. So I am technically in violation of that because we're now under contract. So if I go to a hearing, the best I'm going to be able to say is, mea culpa, I'm sorry. Well, if you're found in violation at a hearing, it's an automatic $500 admin fee. So you may say, hey, I made the mistake. Let me just plead guilty to this, take the violation, and do $350 and 4 hours of education. Or you could say the opposite. Well, what are you talking about? You're saying I didn't submit the offer and objectively as quickly as possible. I submitted it 2 hours after I got it. I am 100% confident if I go to a hearing, a jury of my peers is going to think I did the right thing. So I'm going to deny your citation. If you accept the citation, that's the end of it. The complainant has no say in whether or not you accept the citation. If you deny the citation, the complainant is not even aware that a citation was offered. The fact that you declined a citation is not admissible. We won't tell the panel. We won't tell, the complainant. So the only way the complainant or the panel is going to know about it is if you tell them at the hearing as the respondent yourself, which I don't, recommend. Other things in there are like, 1619. If you put a sign in the yard before you have the right to do so, that's in the citation schedule. But all of Article 16 is not. If you try to poach my client, we're not going to give that as a citable offense because that's something that is actually, more serious violation that needs to go forward to a hearing. If you commingle your earnest money with your operating account, that is not a citable offense. If you talk bad about somebody else's business or their business practices, that is not eligible in the citation. So the panel at the end, we kind of look at what they've decided to move forward, and that's where staff will go, this is eligible for a citation or it's not, and it's an all or nothing deal. So either everything that you're moving forward on is in the citation schedule or it's not. If it's, you're moving forward on 6 articles, 5 are in the citation schedule, 1 is not, it is not eligible for a citation.
Excellent. So we're kind of guided by 3 documents I got here in front of me on the table for you to listen. We got the Code of Ethics and Arbitration Manual. We got the South Carolina Association of Realtors Citation Policy. We got the South Carolina Realtors Professional Standards Policy. So we have an excellent video on citations from Daniel Moskowitz. Please view that. And like Austin said, this came from NAR. And in the past, in the manual, you always had the ability, if it cleared grievance and you were going to hearing, you could always basically plead guilty. Say, I'm waiving my right to a hearing, but you're throwing yourself on the mercy of the hearing panel because they were then going to assign discipline. The good thing about the citation policy, and Austin mentioned it, is it presets. So you would know up front what you're going to be paying and how many hours you're going to be taking. So that was an advantage ahead of time. And to make this relatable, I always call them like, you get traffic citations. If you're speeding, you pay the fine, you move on, or you could ask to go to have your full hearing. So you kind of have the choice when you're presented with a citation as a respondent. Do I take the citation or do I go try to, be found not in violation in a hearing? If it's something that you did, this is a way to avoid all that effort. You heard Mark talk about all the effort that goes into a hearing. You can accept the citation, pay the fine, take the hours of education, and everybody moves on with their lives. Go ahead.
Well, and again, like the if you're found guilty at the professional standards hearing, it's an automatic $500 administrative fee,
Right.
In addition to possibly more. So if
And it's highly unlikely you're going to be found guilty and have no punishment.
correct,
So-
yeah. So you're probably also going to get. I've sat on a couple of hearings where we've stopped pretty much at the administrative fee, but usually there's more, right? Usually there's more, so you might be able to cut your losses sort of with accepting the citation.
Exactly. And so we're trying to promote these. So the ombudsman, please check yes. And on the citation, Austin, talk about when you're on a grievance committee, I call it stacking. You probably have a different term for it. When they want to add a bunch of citations, at a certain point, game strategy is to go to a hearing, right? Can you talk a little bit about what you tell the grievance committee about trying to help get the citation accepted, maybe?
Yeah, so everything that is, again, the citation schedule, the citation panel, if it goes to 1, does not have jurisdiction of going, well, let's offer a citation on, Articles 1, but then they'll go to a hearing on Article 2. It's an all or nothing deal. So if you have 5 things that you move forward on that are all in the citation schedule, and each has, a $350 fine and 4 hours of education, well, now you got 20 hours of education and you got, $1,700 worth of fines. Most people are going to take their chances.
I'm going to say no. I'm not going to accept that citation. I'm going to go see if I can win the hearing.
Yeah. So the goal of the citation, the goal of the citation is to say, and it's like, think of it as a plea deal. For those of you, I know both of you said that you watch, lawyer and crime shows. The plea deal is never the maximum.
Right.
Hey, there's never a plea deal that's, will you plead guilty? And by the way, we're going to give you life in prison with no parole. That's not a plea deal anyone would take. So the goal of the citation is, hey, you made an honest mistake. We want to make you aware of it. And like I said, the respondent has the ability to go, yep, guilty as charged, or hey, that juice is just not worth the squeeze. I'm not going to move forward. Or what are they talking about? I know because the grievance committee nor the citation panel has seen my response, but I've got a really good response. I've got an ironclad alibi. So I don't care that it's a minor fine and minor education. I'm going to win at the hearing and get 0. So it's completely their call. They get 20. Essentially, you get 20 days to respond if you're offered a citation. At the end of 20 days, we move forward.
I do like equating it to a speeding ticket. I either pay the speeding ticket and don't go to court, or use a whole day at court and maybe get an attorney and maybe end up worse off.
Take the points.
Yeah.
Yeah, that's exactly and I'm looking at the policy I just wrote down. So the articles that are in the citation, Austin mentioned, they're kind of what we call minor. None of these are truly minor, but less egregious perhaps. 1, 3, 4, 5, 6, 12, and 16. And then the ones that aren't in the citation policy kind of considered major violations. 2, 7, 8, 9, 10, 11, 13, 14. So Austin, talk about, say there's a complaint, because we're trying to promote citations, right? And so Article 9 is getting in writing. So a lot of times that's kind of thrown in on the side of something. So say it was Article 1 and Article 9 are in the complaint, and Article 9 takes us out of citation policy. What are some ways you could ask the grievance committee to try to look at that? Maybe just go with Article 1 so we could offer a citation.
Well, it kind of depends on the individual case, because we do not have any precedential value, because I've always been asked, well, what has been happening? Each case is tried on its own. So if it's an Article 9 that is not really tied into it, it's the person who filed all 17 articles, it may be much easier to do Article 9. If the basis of their complaint is, you did not act in the best interest of your client, which is Article 1, and the reason you didn't act in the best interest of your client is every time I asked you you took a week and a half to give me my agency agreement. You never gave me this amendment. I still to this day don't have a contract. Then really your complaint is Article 9, and the 1 is sort of an amplification of the Article 9. That's different than I filed an Article 1 because I don't think you were in my best interest. Also, I have an Article 9 complaint because I signed a contract with you on Friday and you didn't get it to me till Sunday. That's a little bit of a different thing there. But, just because you don't necessarily want to dismiss something because it will take it out of the citation, you got to kind of look at the actual complaint itself and the severity of it. But if it's something where it's just an overlap, there's two that, we're talking about being honest and truthful, and there's some other one, the play that's essentially honest and truthful, it's largely the same terms, and that's going to stack, that may be a problem, or one will take it out or the other. But if it's something that is, needs to be moved forward and stand on its own, you have somebody who's routinely not giving copies of contracts or writing their own or something like that, then certainly that Article 9 should be moved forward.
For committee members who have not been on a panel before, who are thinking about joining the committees to give back to this industry, I've chaired or I've sat through lots and lots of hearings at this point, and regularly I'll hear somebody ask you, and sometimes it's me, or asking either you or Chiara or whoever's the board counsel. I'll ask, hey, I've heard people ask, what is precedence? And so what you just said is there is no precedence, but you don't give a $15,000 fine for everything.
Correct. Yeah. So yeah, there are disciplinary guidelines. Generally they're broken down into the code or in the manual that we have as, no harm to the public, minor mistake, ignorance. There's one that's, some harm to the public, not knowing the code. And then there's, major violation, major harms to the public and complete ignorance of the code. So those are taken sort of separately, but, there's not one where you can go, well, hey, we just had an Article 9 complaint last week and here's the discipline, because, these are fact specific. Each case stands on its.
So I wouldn't expect to be on a panel one month and see a $15,000 fine, and then be on the same type of article case, next month, and see that panel going, just the $500 and 3 hours of CE. You wouldn't expect to see like a huge discrepancy then among panels.
Not typically for the same article, but again, the facts may be different. There's a difference in failing to give one addendum on time versus you never gave any documents. Also, both of you can probably speak to this as chair. The attitude as a respondent you come into the hearing with makes a huge difference.
For sure.
If you come in and go, I made a mistake, I
Yeah.
apologize, here's the steps I've made to remedy it. Maybe you bring your broker in charge who talks about the internal, discussions you've had, maybe the internal education. That goes a long way. That's also, by the way, great guidance at the Real Estate Commission as well. But if you come in and decide that you're going to be, fight, and you're going to, certainly advocate for yourself. I'm not saying that if you didn't do anything wrong, certainly advocate for yourself. But there's there's a tone and tenor of which to do it. Don't unnecessarily be combative with the hearing panel. They are the ones who are ultimately making the determination
Be
for
civil, right?
Yeah.
Be civil. Be
be civil. If you made a mistake, you made the mistake. If you know you made the mistake, or don't say, but it's a mistake, but who cares? No one, everyone's made the mistake, or
everybody
no
does
one, or
it.
nobody.
Everybody does it.
Everybody does this, and I'm sure that it's also taken into account of if you are a broker in charge, you're held to a higher standard than a licensee. So if you're a broker in charge and says, I don't care that that's against the rules, I'm going to keep doing it that way, and I'm going to tell all my agents that do it that way, the panel is probably going to treat that differently than a newer licensee who comes in and says, I didn't realize that was against the rules. I apologize. I've made a mistake. I've talked to my broker in charge about how to eliminate this in the future. I've actually preemptively taken some ethics classes to make myself get more in line. Even if it's the same articles that have been violated, those are going to be viewed through two completely different lenses by the panel.
I would also say, having sat on some combative cases, only present what you need to present. Don't go off down rabbit holes. And if you go off down rabbit holes and you are asked not to go down those rabbit holes, don't continue to go down those rabbit holes. Understand the board and the panel's there to help you. Kind of read the room, I guess, a little bit.
So at the end of the hearing, after both sides have had their opportunity to present, the panel basically goes into closed conference and gets to make the decision, right? And so I've been in that position, and you're absolutely right. Like when it was combative, or when one side just kept spiraling through the same topic over and over again, the panel members noticed it, and they I don't know.
Yeah. So your attitude and doesn't we will always remind the panels that you got to take your personal feelings about the parties out of it. You got to take the personal feelings of the parties out of it. But as a respondent, a major element of if you're found in violation of how much discipline is, how aware are you that you made a mistake?
Right.
How contrite were you that made a mistake? If you were indignant that you were even brought to this, and that's going to be treated differently that way. Again, zealously advocate for yourself or hire a zealous advocate for you, but you can certainly be a zealous advocate for yourself without being disrespectful to the panel, being disrespectful to the other parties, being disrespectful to staff.
But like you said, if you come in contrite, like I've sat on two that I can remember where the respondent actually said, "Oh no, I did it. I was wrong. I was wrong. I'm sorry. It was unintentional." And actually went through the whole spiel about, I didn't. I wish I hadn't. But it was a mistake, and the panel definitely we still found him guilty. Still found the respondent guilty, but took that into consideration with deciding the penalties.
You just said something too. You said hire an advocate. I think it's interesting to see how many people bring attorneys, and how many people don't, and how many people who don't bring an attorney and the other side has an attorney immediately become combative because they feel like they're being wronged in some way because they don't have their own attorney.
Both parties have a right to legal counsel, right?
Correct.
Yep.
Yes, and I just want to make it clear that because people again watch these lawyer shows on TV and they hear you have the right to an attorney. If you don't have the attorney, one can be provided. That isn't a criminal case.
Nobody's providing one for you.
That is not. And SCR will not also provide a recommendation or a reference. So every party has the right to an attorney to be at the hearing. The fact that a party has an attorney doesn't mean that they're going to be more likely to win than not.
No, it does not.
Just because one side has an attorney doesn't mean the other side has to. It's perfectly fine if you have a hearing with neither. It's perfectly fine if you have a hearing with both sides having it. It's fine if one party brings multiple attorneys. It is ultimately what you feel like you need to do to best advocate for yourself or defend yourself. You also have the ability to bring what's called realtor counsel, which is you can bring a realtor member to help advocate help you along the way. There are different roles a realtor counsel can take. Realtor counsel is sometimes somebody who's just your good friend that can, hold your hand and just, tap you on the leg of, hey, let's slow down a little bit here. Or it can be somebody who maybe has been previously a member of professional standards and is really knowledgeable in the code. That's somebody you can have in there. And then you also have the ability to have a realtor principal, which is your broker in charge. So your broker in charge is able to be in for the duration of the hearing. They do not have to give prior notice. You do have to give prior notice if you're going to have a legal counsel or realtor counsel, but broker in charge, you do not. So you can have any of those three or none of those three. When you should or when you shouldn't, that's going to be an individual brokerage decision. Talk to your broker in charge about, do we have an attorney to assist us with this? Should we get an attorney? Do you want to be their broker? Am I allowed to get a realtor counsel? If I get realtor counsel, are you fine with it being somebody outside of my brokerage? Does it need to be somebody in my brokerage? Have all those discussions with your broker in charge. That's not advice we can provide at SCR because it's going to be individual and individual brokerage specific.
I do think bringing up the attorney again too, it's important to point out our procedures are different than a court of law. So we allow things that aren't allowed in a court of law. So sometimes I'll see someone come with an attorney and they'll have a written statement that says this should all be thrown out because this is hearsay or stuff like that. We actually do listen to hearsay and stuff like that.
Right. And a couple other things that, we get sometimes attorneys file motions to dismiss or motions for summary judgment. We do not have ability in our process to dismiss a complaint upfront. There's one person on earth who can dismiss the complaint, and that's the person who filed it. That's it. So the motion to dismiss has to come from the complainant. There's no thing you can tell us as a respondent that will say we dismiss the case. You also can't move for directed verdict after the end of the complainant's case. We have to hear both sides. If your attorney brings in state law or federal law cases, certainly you can submit whatever you want. That would be just rule of the panel, but ultimately our governing document comes back to the Code of Ethics. It is not one of those other things. Just like bringing the Code of Ethics to a real estate commission hearing, while you can certainly try to submit that, will not be useful.
Yeah. So looking at the citation schedule, I'm looking through here. So typically the grievance committee, they're going to try to send one citation, right? Because if you stack them, then the game theory is to try to go to a hearing. But all of these, if you go to a hearing and you're found in violation, you've got all the time involved. You're going to have a $500 administrative fee. You can be assessed a fine. You can be assigned hours. But looking through the citation schedule, almost all of them are below $500. There's, for these 1, 3, 4, 5, 6, 12, and 16. A lot of them are $250 fines and a couple hours of education, $350 some education. Some of the more major, citations go up to 500. A lot of them don't allow you if you're a repeat offender. Hopefully you won't have a lot of repeat offenders. So the citation is an excellent way to avoid going to a hearing where you can face more, just like you guys were talking about with the traffic ticket. Take the points, pay your fine, move on, not go to a hearing. So we're trying to push ombudsman and citations. And then we were talking about discipline. So if it does go to hearing, in the manual, one of the documents on page 68, 69, it actually lists some recommended violations for first offenders for different issues. And so our due process, our fairness, after it goes through grievance, it goes to a hearing panel. Hearing panel finds a violation and assigns discipline. The executive committee, which is the board of directors, as a subset, they ratify the case. So one thing they would be looking at, first-time offender for something minor, say somebody just forgot something as an innocent mistake, and the hearing panel puts the maximum $15,000 fine. That's the executive committee, as they're acting for the board of directors, when they ratify it, to reel that back in, or even send it back to the hearing for discussion on that. So the executive committee can always reduce discipline or send it back to the hearing panel to reconsider some due process issues. And all this is to help keep us within the lines of due process, so the association doesn't get sued. So we're pushing ombudsman, we're pushing citations, because those help us avoid hearings on that.
Talking about the evidence that attorneys might want to present or that people present. So, the panel itself, who's hearing the professional standards hearing, the chair and the panel get to decide whether evidence is admitted or not. So if there's new evidence that wasn't
they get to
originally,
determine new evidence.
submitted, yeah,
Correct. They get to determine new evidence. When you file your original complaint
Yeah.
or your original reply, that is considered already in evidence, which
Yeah.
means also if you're at a hearing, there's no need for you to reread your complaint or your response because it is already in the
I've
record.
already read it.
Correct.
I sat there and the week before and looked through the whole 300 pages or 2 pages maybe.
Yes.
Whatever it was.
But if you want to submit something at the hearing, that is the right of you to submit something at a hearing. But we'll have to go in executive session for the panel to review it, as well as the other side to review it. And depending on how voluminous you are submitting additional documents, that may be a 10-minute recess. That sometimes could be a couple hours. We've even had it before where they've submitted so many documents, the other side has said, we weren't prepared to defend all this. We need to recess this to a different date. Ultimately, the panel makes a determination at that hearing of whether or not it's allowed in, and the basis is relevancy. It's not based on anything else. Is this relevant? And it could be you submit 10 additional documents and they go, these 3 are already in your complaint. These 2 are already in the response. These 3 have absolutely nothing to do with this hearing, but we'll allow 9 and 10. And obviously the parties can object to that, but that's the thing. But try to get as much of it in beforehand, because if you're worried whether or not it will be admitted, the easiest way to do it is to put in your complaint or your response because it's already in the record.
What's our current timeline? If someone submits a complaint today, how long is it typically taking to get to grievance and then to professional standards?
So under the rules, if you submit a complaint, it has to go to grievance within 45 days of receipt. So that's where I always tell folks, well, I'm not sure if I want to submit a complaint. I don't know whether it's a violation or not. I said, file a complaint. Within 45 days, you will know an answer whether or not you should move forward. If it's dismissed at grievance, we never even notify the respondent, because there's no need to send you a letter, James, and say, hey, by the way, Mark filed a complaint against you, but we dismissed it. Because that's just going to create tension. So once we get it through grievance, then it goes to the respondent. The respondent, I believe, has 15 days to reply. So we're now at 60 days out. Then we have to go and schedule it for a hearing. Obviously, we have any sort of stopgaps for if there's citation or ombudsman. But if we schedule for a hearing, we typically give at least 3 weeks notice for a hearing, but we have to schedule a date for the parties. So you're probably looking 2 to 3 months, best case scenario, unless there's any sort of abeyance or other things going on there. But 2 to 3 months time frame.
And they have how long to appeal?
20 days. And that's both at I believe it's 15 and 20 days. Anytime you want to appeal, or any of your deadlines are going to be clearly laid out in the form. So if what the form says is different from what I'm saying here, go with what the form says. But the appeal for the grievance process, I know Mark asked that earlier. The grievance appeal has to be, you guys misapplied the code, or here's what you weren't thinking of. And there is the ability of the grievance to go, I forgot this document. This would be more helpful. And typically that just gets sent back to a different panel. For an appeal of a hearing, it has to be for 2 reasons: either substantive or procedural due process. Procedural due process is, you didn't give me proper notice of that the other side was going to have an attorney. You didn't give me the ability to bring witnesses. It's some sort of procedural issue. Substantive is, you misapplied the code, or I submitted an offer a day late and you fined me $15,000. You can't just appeal because I don't like the decision. It has to be that there was some due process issue, either procedurally or substantively.
And if there is an appeal, I assume that sometimes it has to do with the panel members themselves.
Yes.
Maybe not paying attention or not.
Yeah, we've been pretty lucky about locally, but certainly that is a grounds for a procedural due process. Would be every time I went to when the complainant was speaking, everyone was on their camera. They were fully paying attention. When I went to speak, 3 of the 5 panel members turned their video off. One of them started eating their lunch. They were rolling their eyes at me. They didn't ask any any questions of the complainant. They badgered me as the respondent. They called. It was a member of the public filed a complaint against a realtor member, obviously, and the complainant they referred to as Mr. or Mrs. So and so, and it was me. They would go, Mark, James. So we always parties are paying attention to that stuff. So treat everybody the way you must be treated, honestly, fairly, being in full attention, because that's sort of the low hanging fruit for an appeal is, I didn't get a fair hearing because of this reason or that reason.
All right, so we kind of talked about grievance committee on Articles 1 through 16, and we talked about the ways that we try to avoid a full hearing, either with ombudsman trying to come up with alternative solutions or citations. We've talked about the grievance committee or check and see if it's a realtor, if it's filed within 180 days of when they should have known about an issue. Does it fit within the articles? We talked about don't do your own research, but do read the materials ahead of time. Kind of the number one thing, get prepared ahead of the Zoom. So there's one more article, Article 17, which is kind of our arbitration. This is typically brokerage on brokerage. Pre-settlement, it was usually the buyer is the villain. They jump between buyer agents in different brokerages, maybe not even telling them that they already are working with somebody. The cooperative compensation is in the MLS. The broker v. broker, they're both participants in the MLS. The deal closes. That's kind of our classic arbitration. So Article 17, arbitration is the thing that come into grievance committee. Austin, post-settlement, what are some changes that are on the horizon for arbitration? In procuring cause, I was on a Zoom with NAR recently, said procuring cause is not dead, but it's definitely changed under the settlement rules. What are you forecasting on arbitrations?
Yeah, so probably the biggest fundamental change is the number one thing that we look at for you to have a valid arbitration claim is there has to be a contractual basis for compensation. August of 2024, it was usually, hey, I'm an MLS member, you put an offer of compensation to the MLS, that's our contractual basis. Now with no longer being there, you're going to need a contractual basis, which is typically going to have to be a compensation agreement. So you're going to have a situation. You would no longer have the situation, Byron mentioned of, Mark is Byron's buyer client. Byron goes out of town for the weekend. Mark goes over to James' open house, signs a contract with James, and then Byron says, hey, that was my client that I showed that way. What the only way it would work now would be is James would have already had to have a compensation agreement with Byron for Mark and didn't do the due diligence of checking that out when he went under contract. Because the first thing they're going to ask from Byron is, well, what's your contractual basis? And if all he says is, well, I had a buyer agency with Mark, they're going to go, well, that's not arbitration. That sounds like Mark breached your buyer agency agreement. You need to go after Mark. We do not have the ability to compel Mark there. So you're going to have a contractual basis between the two parties. Or there was a compensation agreement, between Byron and James, and we get to closing, and James tells the closing attorney to pay Byron less than that compensation agreement. Then we would be able to arbitrate for that difference, but there has to be a contractual basis. So if there's no contractual basis with another realtor firm, it's not going to be arbitrable, because that's one of the first things. For it to be mandatory, it's got to be a realtor to realtor firm, and there has to be a contractual basis to do so.
This might not make it onto camera. We'll see. But for contractual basis, Form 120 compensation agreement is what's being used commonly in South Carolina, provided by the South Carolina Realtor Forms Committee. What about when agents text each other or send out emails with offers of cooperation or co-broke type stuff? Is that? Do you think that that's going to make it into arbitration in the future?
So that would not be an arbitrable matter. So if James had a billboard that said, "I offer on all my listings," Byron can't go and say, "Well, I have a contractual basis because I drive I-26 and James has a billboard on it."
Yeah.
It's going to actually have to be a contractual agreement.
That's advertising.
That's
advertising.
It's advertising. Same thing with the text message of, Byron texts James, hey, are you offering cooperating compensation on 123 Main Street? He says, yes, we are. It's whatever.
We're giving away a penguin. There you go. And so
and Byron never sends the follow-up paperwork. Neither is James. Byron can't then claim he's the procuring cause for arbitrable reasons because he doesn't have a contractual basis.
But in theory, could I file a Article 1, you were dishonest
Correct.
type complaint instead? So it's not in Article 17, it's the wrong article.
Correct. That may be in Article 1. Hey, you weren't honest and truthful in your real estate community. You weren't honest with everybody.
You sent me a text telling me that you were giving away this if I brought you a buyer and
correct.
And now you're saying
Article 12, you weren't honest and truthful in your real estate communications. That may be enough again to get through grievance, But then at that point, James would be able to go to a hearing and maybe as a respondent go, I was honest. That is what I was offering. That is, here's my listing agreement, which says that's offering. Here's the text messages. Byron just never sent me the paperwork.
Yeah.
So why am I going to be found in violation for somebody not sending the paperwork?
For somebody else failing to do their part. Yeah.
Yeah, and so one of the ways, because it's going to change, right? And this just changed in August. Basically, the MLSs took the cooperative compensation out of the MLSs, but mediation is still there. So if there's two brokerages fighting over some money, maybe they try to mediate. Because the other thing that comes up on grievance committee has the ability to say, hey, this is way too legally complex for hearing panel realtors. We're releasing you realtors to go out and get in front of a judge where a judge knows contract law. So we may see some of that because it's going to be very complex, very unusual situations. Who's got a compensation agreement? There might be multiple compensation agreements that are enforceable. But at the end of the day, our hearing panels are realtors. They're volunteers. They're not lawyers. They're not judges. So the grievance committee has the ability to say, hey, this is too legally complex. SCR can help you with mediation. You can mediate and try to work it out before you go to court. But we may, the grievance committee may release the realtors to go into court and get this resolved because money is important to realtors. That's how you put food on the table. So there's various other remedies besides SCR where you can chase and get your money. You can, if there's a 120, a compensation agreement, somebody breaches that, your trial lawyer can sue for that money. And Austin, the forms committee worked hard. Board of directors yesterday just approved some updates on the forms. So stay tuned. Austin's going to be talking about the updates to the compensation agreements. If your buyer signed a buyer agency agreement and they were a villain and didn't pay you and went off with some other buyer agent, they're in breach of the buyer agency agreement. So your brokerage can hire a trial lawyer. And I know people don't like to sue their own clients, but that's another way that you can go after your money. All right, I guess we're shifting over to the hearing. This is kind of Mark's wheelhouse. Mark, when you're a chair, what are some things you're thinking about when you're assigned? When Lindsay Pittman assigns you as a chair for a hearing, what are some things that go into your mind? Like, hey, I need to put on my chair hat, my thought process. What are some things you're thinking about as chair when you're chairing one of these ethics or arbitrations?
First thing I usually do is go back and read the articles that are being presented or that the complainant is about. So I read the articles, make sure I understand the articles. Sometimes that means that I reach out to one of you or Tiara to kind of get some guidance as to am I understanding the article correctly. When make sure just again reading all the documents, like going through everything that was presented and trying to make sure that my brain is not predisposed towards one side or the other right away. Recognizing that everybody has their opportunity to present their case, present a rebuttal, present cross-examination. So getting on the panel, when we actually get to the Zoom and I meet the panel members. Sometimes I know them, sometimes I don't. And just kind of, we do a little bit while Austin or Tiara or whoever's counsel for the day is talking to the complainant and the respondent. I'm usually sitting there talking to the other people in the thing, hey, how have you already been on cases before? What are your expectations today? Because sometimes there's a new panel member. Sometimes they've never been on one and they don't know what they're getting into. They don't know how long it's going to take. So just kind of prepping them. I do block out the day because you don't know how long it's.
I was about to say, we don't know how long it's going to take.
Yeah,
either.
we don't know how long it's going to take. As a chair, I don't know how, if I'm chairing a panel, I don't know how long it's going to take. Again, sometimes as a chair, I'm going to be reading a script that kind of explains the process to the respondent, to the complainant. I'm going to introduce the people in the room, introduce whoever else is sitting there as a panel member. I'm going to, if all I do is read the script and everybody says 2 words as part of the process, we're still going to be there for pretty close to an hour. It's a lot of script to read, a lot of dialogue to go through, and a lot of due process to make sure that each side has their opportunity to give their opening statement, to then go into providing the case, why they think that we're here, to having the questions from the panel members to clarify what was said, to have cross-examination from the other party, to ask questions, and then to just basically make sure that everybody can disclose as much as they want to or feel they need to during the process. As a chairperson, you have to be patient. You have to kind of control the room just a little bit in case one of the parties it starts to spiral. As a chairperson, you have to pay attention to if the other panel members want to call for a break, maybe a comfort break, maybe council questioning, just to verify whether or not we can consider something or not, or whether we can even ask a certain question. Sometimes there's questions that shouldn't be asked. And I want to verify with Tiara or with Austin whether it's a viable question to even ask. I hope that kind of explains a little bit where my brain goes.
Yeah, that was very interesting because I never really thought about that before as chair. You might not even know the folks that are on your panel.
That's right.
That was very that's enlightening to me.
Yeah, as I've been doing this longer, more and more of them, when I join a Zoom, more and more of them, or when I get when Lindsay has emailed us the information, more and more times I'll know who they are at this point, just because I've been involved in the process for a while. Yeah.
Super. And we shifted kind of to Zoom back in COVID, and we've continued because everybody likes it because like Austin was talking, for conflict of interest, we try to pick people from different cities, right? And it can take 3 hours to get to Columbia for some of these realtors, or say you're a seller and you've moved to California, you might not even file a complaint because you're like, I'm not flying back to Columbia, South Carolina to file a complaint on my realtor, even though I'm mad as heck at them. But with Zoom, they can do that easily. Everybody's comfortable with the technology now. We can do breakout rooms. We record it because on appeals, they're going to get they're going to get the transcript because they're usually, if they're appealing it, they're appealing on due process, trying to find some sort of mistake by the SCR, our board counsel, our hearing panels. And you talked about the script. You talked about the opening. They do their opening statements. And on board counsel, a lot of the mistakes we see, because these people they're not lawyers most of the time. They never had, trial courses. They'll want to go straight in from opening statement to their case. So you kind of have to clearly say, look, opening statements where you're kind of framing the issue, and then your case, when you get your chance, you're going to be filling in the painting in the middle.
My process now when I'm chairing is to actually double down on that. So the past few that I've chaired, I've read what it says on my script, and then I'll look up at everybody and go, no, seriously, 1 to 2 minutes. Just go, hey, all you're doing is just saying, here's why we're here and here's what's happening.
That's a good point because you're dealing with human beings. So you got to be very explicit because everybody's nervous, right? The person, even the person, the complainant's nervous because they're not used to this. And certainly the respondent is nervous. And then they're going to be able to cross-examine at a certain point, and then they do closings. And you mentioned, Tara, Austin, when they're doing board counsel. Austin, when you're on a formal Zoom like this, what's kind of your purpose? What's the purpose of the board counsel? What are you and Tara doing to help the panel? You're not helping the complainant or respondent, right?
Yeah, so we made clear to everybody that we are not there as the complainant's attorney. We're not there as the respondent's attorney. We are not there to help the complainant with their case. We're not there to help the respondent with their case. I tell both parties when I meet beforehand that the goal of staff is at the end of the day, whether you won the case or lost the case, you felt like it was a fair hearing. You felt like everybody in the room treated you with respect. The panel was respectful and listened to you. The staff was respectful to you. You had adequate time to state your case. You had adequate time to ask the other party questions, and any questions that were asked of you were done in a respectful manner. So even if you didn't win the case, you felt like it was not a waste of your time. You didn't feel like it was a kangaroo court. You didn't feel like you were, especially we get that with members of the public who have some apprehensions of, I'm going in front of a jury of realtors. Well, surely they're going to side with their own member, and you have to say, no, they're here to treat all parties fairly. Honestly, they do. You do not come into a hearing with any preconceived notions. So just like we said with the grievance, if you read through a complaint and go, as a panel or professional standards hearing panel member, go, that same thing happened to me last week. I didn't get, I can't be honest on this one. This is one there. I just have too many preconceived biases, then just let us know. Hey, this one hit this.
I'm still angry about
Yeah,
what happened last time.
Yeah, this one hits a little too close to home. I don't want to do this one, and that's fine. When to tell us that is not beforehand. I know Mark mentioned that, hey, there's a lot of talk beforehand. One of the only things you're not going to talk about is what does everybody think about the case. Yeah, there's only one vote that's ever taken of whether they think something occurred, and that's at the end when when everything is done there. So our goal is really to make sure everyone is feels like they have a fair hearing. We're there as board counsel. We're there to help the board. That does not mean myself, Tier, Lindsay do not get a vote. We do not. In fact, panel members, if panel member asks, well, what do you think? Even afterwards, we won't tell you. So it's one of those that better, the question I think Mark mentioned is, sometimes people want to do an executive session to ask how can I ask this and how should I ask it? So common one would be, hey, there's a contract or an agency agreement that wasn't provided in this, and I really want this agreement. And so they go in executive session and say, hey, can I ask the other side? Can I ask the seller to give me a copy of the contract? Can I ask the buyer to give me a copy of the contract? Go, no, because again, that looks to the other side like, hey, give me this document. It looks like,
I'm trying now. The panel is trying to prove guilt,
correct.
Basically. Yeah.
And so I said there's a more artful way to do it. You can say, did you guys have a written agreement? Yes. Okay. Well, who was it between? When was it signed? When was it dated? And eventually they'll go, I've got a copy.
Don't you all have that already?
Yeah,
no,
I've
we
got
don't.
a copy. You'd like to see it. Or they'll tell you, I don't remember. I don't have it with me. So you've gotten the answer you were ultimately looking for, but you did it in a more probing way without a direct ask for that particular document.
I think it's important to make sure you have an open mind and are impartial throughout. I chaired a case where I believe the person who actually ended up winning the case felt I was probably they felt I was impartial because they thought I was on the side of the realtor. And as it turns out, I had to put everything aside and decide the case at the end of the day. So I think it's important for members of the public to know we really do look at these impartially, and we really do want to make sure everybody's living up to the code, regardless of how many deals I've done with Mark.
Well, and going on to that point, members of the public should, if they have an actual case, they should file the case. And as as realtors, we don't like working with bad actors. We want the professionalism. We want to see it go to a hearing if it needs to go to a hearing. And so it's not, if the public believes that realtors are going to side with realtors, I just don't see that that's the case. I really don't.
But one way to kind of get rid, to help with that is, if you're on a panel, don't wear your R pin, don't wear your broker's name tag. That's not a day to wear your SCR polo. Like that's, try
or
to
have your background with your logo.
Yeah, be more impartial. And I'm sure you've both heard me say this is just because you're found, just because a person's found in violation of our ethics panel doesn't mean that they're the worst person in the world and they should never be able to practice real estate. And just because they're found non-violation also doesn't mean that everything they did was exemplary and it's a gold star.
I've been on a couple of cases where basically the entire panel wishes they didn't have to vote against somebody. Maybe this is going back earlier to the demeanor of a respondent or a complainant, and everybody's like, we really feel bad, but the right thing to do is to vote against the respondent. And I don't know.
So, Mark, is the vote that y'all take in panel, is it guilty or not guilty? That's not the vote that y'all take.
It's not a guilty or not guilty thing at all. No, it's a yes, you violated Article 1, or no, you didn't vote.
And how is that proven?
It was proven by the complainant. So the person filing the complaint needs to provide the evidence, the witnesses if there are any, as much documents as possible. I've seen text messages, I've seen phone logs, I've seen
voicemails.
We've heard voicemails. Yep, I've heard voicemails. There's all kinds of ways that the complainant can.
But the burden of proof is on the complainant.
The burden of proof is entirely on the complainant.
And that is how the findings of fact are written. Yeah. It is based on the evidence provided. The panel felt that the complainant did or did not carry their burden of
Yep.
clear, strong, convincing evidence, which really means a firm belief. So that's where I always go, and both of you, I'm sure, have been on panels where you're going, I left this hearing just as confused as I came into it with, and I don't think there's the buyer's side, there's the seller side, and then somewhere in the middle is the truth, but we'll never know what the truth is. And at that point, the complainant didn't prove their case. It doesn't mean that the other side did exemplary work. It doesn't mean that they did bad work. It just means we can't make heads or tails from this. So we've got to
maybe that's where the complainant should have hired an attorney, maybe to try to streamline it. And it's okay for the panel members. It's okay to vote differently and to have a different opinion than the other panel members. That's okay.
Right.
We're looking for what? A majority, right?
Right.
It's just a simple majority.
Yep.
That's why we do an odd number. You have 5.
And I think it's important to speak up. I several times I've been, on panels where it looked like everything leaned this way, and then you have one panelist say, "Well, did you pay attention to this, or did you notice this?" And then everybody's like, "Oh, wait,
12 angry
no, we
men.
didn't."
12
and
angry
then,
men.
it changes things.
And going down that one more time, so if the complaint was, Articles 1, 3, and 12, the panel's hearing, so first grievance decided to send all 3 of those forward because there was probable evidence that there should be a hearing. It's okay that the panel says yes to Article 1 and no to Articles 3 and 12. Like that's very common for there to be a split. The complainant proved with clear convincing evidence, Article 1, but not the other ones or whatever. So it's okay for the panel to, it's not an all or nothing verdict.
Right.
Yeah, and if there's 2 respondents, then you're actually taking each individually. So in your case, there would be a vote on respondent 1 for Article 1, respondent 2 for Article 2. And sometimes I think you've been on the panels where the article that they're found in violation of is the only one that they didn't even talk about in the hearing, but the actual physical evidence was so...
Nobody needed to talk about
Correct.
it. It was right there in front of us.
Correct. Yeah, but you spent all this time talking about some other side issue that had nothing to do with that. So you've got to kind of divorce that from your mind of we're only here on these, and that's where you kind of look at the individual elements of each article. But I think that's the common misunderstanding is that, well, I was found guilty or not guilty. It's actually not guilty or not guilty. It's was the burden of proof met, and that is the job of the complainant. It is your case. If you're the one who files a complaint, it's your job to prove the complaint. The respondent does not have any obligation to prove their innocence. They can certainly present evidence to rebut what you bring, but the respondent does not have to prove their innocence. The complainant has to prove that there was a violation.
Great.
Yeah, good point. Because the grievance committee is only hearing the complainant side. We don't provide the response to the grievance committee. So you could easily have a situation where, say, that sewer septic issue where the agent and the broker in charge are sitting there in the hot seat. They've been alleged and grievance committee sent 1, 3, and 12. And then the hearing panel, after hearing the clear, strong, and convincing standard of proof, say Article 1, they find a violation. They might find no violation for 3 and 12. They might find a violation for the agent, not from the broker. And then you guys were talking about questions. I like the way you guys were talking about very precise questions when you're asking from the hearing panel, because you don't ever want to be perceived as preachy, because we're going to read about that in an appeal.
Yeah, so a question that starts with, don't you know, or shouldn't you know, or as someone who's been licensed for X number of years, don't you don't do that.
Yeah. And all this is highly confidential, because we were talking about before we started this, we got to be careful when we talk about cases, because we're not allowed to talk about cases, dates, and individuals. So everything's highly confidential. So on the hearing panel, we tell the hearing panel and the grievance committee, destroy any kind of documents you got. When you're on the hearing panel in your Zoom, have a private space, hopefully with a locked door, not driving your car, private space where you're not distracted, because we'll read about it in an appeal. If they see the hearing panel person, they're texting during the hearing, or they're not paying attention, or if somebody comes in and out of the room. So also, what are some things you tell the hearing panels regarding confidentiality? How do you reinforce this and drive this home?
The easiest way it gets through it is Article 14 says that it is a violation of the Code of Ethics if you disseminate information from our hearing. So if you go, or if you're a hearing panel member and you go back to your office and say, you won't believe the hearing I had, and someone files a complaint, you're going to get to see a hearing panel from the other side
Right.
of the Zoom meeting, so to speak. So making sure that you don't, if you print anything out, that you're going and grabbing it from the printer, not leaving it in the printer. One of the biggest things we see is if you're on a team, or if you or your spouse share an email address and you serve on professional standards agreements, we need a separate email address, because the person who's on your other people on your team or your spouse should not be privy to that information. So just being confidential, don't go, hey, this is a great idea to take this back to my office meeting of what I saw, learned. So don't get your brain trust in your office together to help you work on it. It truly is confidential, and a violation of that is a violation of the Code of Ethics.
Super. And then kind of shifting for, if you're a complainant, this part of the video is kind of for you. You're a member of the public or for a realtor. And then I guess we'll start James this time. James, say a realtor comes up to you and asks you about, hey, should I file a complaint? What are some things what's your thought process, and what do you say to a colleague that's asking you about filing an ethics complaint?
I first off, verify, is it a Code of Ethics thing, or is it a legal thing? Is it, are you just mad, or your feelings hurt? Is it an actual violation? And then, a lot of times I'll say to people tend to say, well, I'm gonna have to work with Austin again. I don't want to file a complaint against. I tend to retort to that, do you want to go through this again? If it's that big of a deal, if it's a true ethical violation, file the complaint. So I get a lot of people will come to me and say, this happened, are they going to be found guilty? I have no idea. I don't know the facts of the case.
Well, now that they've talked to you about it, you're not going to be on the
Yeah,
case. You're not even going to be on it.
I'm not going to help you fill it out.
So guess what? I have no idea, because I won't even be one of the ones voting.
Yeah, especially if I'm on grievance, I'll never know where this went.
Yeah.
But if it's important, probably if it's important enough to come talk to me, and you don't work for me, you should probably file a complaint. If you work for me and I'm your broker, then it makes sense to come talk to me about things, and we can talk through, does it make sense for me to reach out to their broker, or for you to file a complaint or not? I do caution all of my agents and anyone who comes to me, be careful what you say about another realtor, because that in itself can be an ethics violation. So if I come to Austin and I say, Mark's a horrible realtor and he did this and this and this and this, that is an ethics violation if I am not telling the truth. And
you're telling the truth.
Yeah,
yeah.
I mean, so you do have to be careful what you say about other people and who you're talking to. So I always caution people when they come to me and say, so-and-so did this, be careful. And if you're going to come to me and say that, you should probably want to file a complaint. You should probably have evidence to file a complaint.
And whatever you put in the complaint, just remember, if it's a successful grievance, it's getting sent to respondent. So
Yes.
I tell folks that all the time. It's like, make sure anything that you're going to put in there, you're fine with the other side reading, because it's going right to them after grievance.
Right.
In filing the complaint, again, the burden of proof is on the complainant. So they're going to need to make sure they've got evidence.
Well, I was going to say, you need to make sure everything is in the complaint, because generally the panel's not going to come back to you and ask follow-up questions. So if you say there's a problem with the contract, you should definitely include the contract. You should, make a good argument, a concise argument, preferably a smaller argument that's just to the point. But make sure you put all the pertinent information in the complaint whenever you initially file it.
Yeah, it's a good point, because you're dealing with human beings. So name the articles, be plain language, concise, simple. Austin, what's the largest complaint package that you've seen come across your desk?
400 plus pages.
So try to be concise.
If I'm on, that means the grievance panel had to look at 400 pages.
And
you're trying to, hey, I've alleged 5 articles. Now you've got to go find the details for each of the articles in the 400 pages.
Yeah.
And 200 of them are too long. So example, we get routinely, and both of you have probably seen this, we get an entire inspection report.
I was just thinking the inspection
and
report.
the inspection report, the only issue with the inspection report is about some baseboards on the first floor.
Yeah.
It is perfectly acceptable in your complaint to submit the front page of the inspection report that shows the inspection report, maybe the summary page, and then that relevant page. No one is going to ding you for only giving 4 of the 50 pages of the inspection report. The other 50 pages is just clogging it up, and now we're, parties are having to go, okay, well, which baseboards are they talking about? If you're talking about a particular set of baseboards,
panel members are confused at that
Yeah.
point, right? And so now it's hard for the panel members to come to a
I'm old school. I
consensus.
like to print things. I like to.
Yeah.
So generally, if I'm on a panel, I'll work from home that day. I'll sit at my kitchen island. I'll make sure the dogs are put up, and I'll have everything in front of me. And if you send me a 200-page inspection
Yeah.
report, which is just a bunch, it's a lot. So
and if you're working on a contract and your only issue is on the final contract, sending the previous 6 versions of the contract
And all the
now just confuses the panel, because they're going, well, which contract are you talking about? So sometimes it is important to have the full timeline and the full chronology, but sometimes it's not. So
I've seen text messages as evidence with no timestamp on them. It's impossible to guess which party is which side of the text message, like things like that too, that are really confusing for the panel members.
I mean, some of the best put together complaints I've ever seen have been 10 pages or less.
Yeah.
Because they come at you like a Mike Tyson punch. It is very direct. It is, here's this article. They write a 1 to 2 page beginning narrative of, here are the 5 articles I'm alleging, and here's the, almost an opening statement. Article 1 is about honesty. Here's where I think they weren't honest, and you'll see an attached exhibit. The Article 2 in this exhibit. And it's very easy for the panel to follow, and they're not giving you any more information than you need, because their case is so good and ironclad that they don't need to drown you in information. They've got just the basic parts. If you're doing an advertising complaint, send us a complaint form, maybe a 1-page write-up of the advertisement, and then submit the advertisement. We don't need we don't need the picture of the yard sign from every which angle. We don't need it at night. We don't need it during the day. We just need, hey, they weren't honest in the yard sign. Don't overcomplicate it.
You're dealing with human beings, so be direct, be plain, organize, use an outline, use a timeline, be very clear. And then Mark, same question to you. A colleague or a client comes to you and says, hey, this happened to me. Should I file a complaint? What's kind of your thought process, and what are say somebody that's working for you, one of your associates, or even one of your buyer clients comes up and asks?
I mean, to be honest, I encourage people to file a complaint. If there's evidence, they should file it. If it's just emotional, if you just want the apology, go do mediation. Go to mediation, ask for the apology. But if there's a viable complaint, and if there's an agent that has a reputation, or if there's somebody should file. Somebody needs to do that. So I do kind of the same thing that James does, which is clarify that, maybe this is a ethics thing, maybe it's a license law thing. I usually break it down like that for people.
maybe you have 2 complaints. Maybe you have
maybe you have both. Maybe you have all 3. Maybe you got civil action as well. Who knows, right? Maybe it is possible to have everything there.
I always tell people, the worst thing, if you file a complaint, the worst thing that's going to happen is in 45 days, you're going to get an email from us that says your complaint was dismissed,
Right.
and the respondent is not aware that this was filed. So you were out the time it took to fill out the 1-page complaint form, fill out whatever the complaint is. In 45 days, you have an answer, yes or no, and then you can at least go, well, hey, I wasn't sure if this is a complaint or not. You can then rest easy going, hey, I filed a complaint. It obviously didn't meet the merits. It doesn't mean necessarily that everything was okay, but I at least now know, I now have an answer. It's not, I have closure on the issue.
I think that sometimes I hear things from people like, the system doesn't work from realtors. I filed the complaint and they didn't even take it. And so that doesn't mean the system doesn't work. That means the system does work.
Right.
Like that's
It means you didn't have a good enough argument.
Yeah, that means that means the system does work. So don't let that discourage you either. If you're somebody who needs to file a complaint, if you're a realtor next time around, file again. On a different situation if you have to. Don't think that the system doesn't work just because your case it didn't go anywhere or because you lost your case. The system did work.
People usually don't think the system works until they're on the opposite side of the B.
Yeah.
And then all those stopgaps that were annoying as a complainant are now a godsend as a respondent.
I mean, in license law, what does the commission say? They get like 1,000 complaints a year.
Mm-hmm.
And how many of those actually turn into an actual license law violation against somebody? It's minimal compared to that number. Same thing here. Like people should file anyway. They might not all stick, and you might not have done a good job presenting it, but the system does work.
One reason we're making this video, we're also recruiting, right? We're trying to get realtors involved in grievance committee and professional standards committee because On the legal side, our forms committee and our legal action committee, those are limited number of seats based on the parameters of the policies of those two committees. But grievance committee, professional standards committee, we need people under statewide professional standards. The local board send us 5 realtors each, but we can take more. And we're getting to the phase now where we need to start training folks, new folks. So James and Mark, I guess we'll start with Mark this time. What's a good skill set for a realtor if you were recruiting somebody to be on a hearing panel with you? What kind of skill set do you look for?
Patience, open ears. You're going to need patience to hear the thing. You're going to need to not jump to conclusions. So that impartial mindset of just being fair, and then somebody who's passionate about it, somebody who wants to be part of the process, somebody who wants to see the system keep working.
Super. And then same question for you, James. If you're recruiting somebody to serve on a hearing panel with you or a grievance committee, what are some skill sets you would like to see?
I agree with the passion, and you have to be engaging. You have to be motivated to make the process work and make, as a group, realtors be better. Don't just jump on the committee and expect to do nothing. You're going to read a little, you're going to learn a little bit, but be open-minded and be engaging.
Super. And then also what we say a lot of times is when we're the board council, we'll say, look, when you're on a panel, you're being trained to be a chair. So pay attention to how the chair operates and borrow the good elements and discard the bad elements. We'll flip and we'll go to James first. For a chair, what's a skill set for a chair? What do you think makes a good chair?
The biggest skill set for a chair is to be able to read because it's pretty foolproof. There's you have a template and you read it, and Mark alluded to this earlier. It's pretty long. The first time I was asked to chair, I was terrified. And then she was like, no, I have something for you to read. And then it's not really that hard. You just kind of follow your template and read it and be impartial. You, depending on, which your own professional standards or grievance, you will have to answer questions on the spot if somebody objects to something. So you have to be focused and aware of what's going on and just make sure you're impartial. But it's not as scary as it sounds. It's really not. They set you up for success.
Super. And then same question for you, Mark. For a chair, what's a good skill set for the chair for these grievance and professional standards?
Just be able to be calm and show that professionalism. I think when you talk about engagement as a chair, one of the things that I do with the panel is direct questions to each of the panel members too. When you're coming to that consensus at the end, to the vote at the end, make sure that all the panel members have had an opportunity to ask questions. Sometimes I've been on a panel and everybody's asked a question except for that person. So I'll actually say, James, do you have any, did you have any questions about this before we move on to the next part of the script, right?
Mm-hmm.
Next part of the script. I think it's good to have for everybody to have the voice, and a good chair kind of pulls that out of the other panel members.
Super. Yeah, that's a good point you made about the executive session. So you go through the full hearing, and then you dismiss the parties, and then the board council's there to make sure you guys are following due process rules. But you have an executive session. What are in executive session? How do you kind of handle? What works best for you when you're chair? Do you let everybody speak, or how do you handle executive session?
My personal method is I don't try to introduce things. I try to hear the panel members first. I want somebody else to make a motion, and I'll actually sit there and I'll say, "All right, James, you've talked about that a couple times. Austin agreed with you. Do we have a motion on the table? Yes, we have a." Then James says, yes, I have a motion. To find.
I'll sometimes say
to find the violation. Yeah, to find. Yeah, that sounds like a motion. That's a good way to say it too, because you really do. You need to follow the Robert's rules just a little bit to get it to a vote, to make sure that everybody's had an opportunity to discuss and to vote on, to ask the questions that they need to review the evidence. A lot of times when I'm in that executive session at the end. That's where the panel will start saying things like, did you see page 13? Did you guys understand that? And I'll be like, I wish we had asked that question during the during the actual hearing. But sometimes it's okay. Sometimes there's a little bit of consensus about yes, this is how I understood it. No, it's not how I understood it.
And then for you, Jay, when you go into executive session, what's some ways you've seen it?
I agree. I think when you are the chair, people try to look to you to kind of lead the conversation. So I try to let others give their input first before I give my input, because
I don't make the motion.
Yeah, I try not to.
I choose not to.
But that doesn't mean I don't have my opinion, and
That's
I'll
right.
definitely share my opinion.
Yeah.
I want to hear everyone else's opinion first. I don't want them to just say, yeah, I agree with what Byron just said. I want them to say how they feel. So I'll generally let everyone talk, and if I notice someone isn't speaking, I'll point to them directly and be like, Mark, what do you think? Just to make sure there's it's not just one person running the show or two people running the show. Make sure there's general consensus.
Yeah, you don't want groupthink where just everybody follows one panel member. You want to have the entire panel have an opinion and vote.
And like I said earlier, sometimes it's that quiet person that'll say, well, what about this? That makes
That's right.
everyone stop and think and go, oh, actually, you're right.
Super, excellent. And what are some ways that you guys stay current with professional standards and your skill set as hearing about it? What are some things you do personally to stay current with professional standards?
Well, I read I know LLR and SCR are different, but I read any ethics class I can take. I read the stuff that comes out of LLR. I like looking up standards of practice and just kind of staying in the know of what other cases have been decided. And because a lot of times I'll see something and be surprised, and then I kind of dig in at why did they do that way. So just kind of getting information from multiple sources.
And same question to you, Mark. How do you stay current with professional standards?
Periodically going back and reading through Code of Ethics helps for sure. And just kind of remembering, what it is. For me as a broker in charge, with my office meetings, a lot of times we'll have a topic, and I will, I'll talk about the topic, and I'll talk about it from, here's the topic today. Here's what license law says about it. Here's what Code of Ethics says about it. So I literally compare and contrast for my agents at my brokerage a lot of times. Serving on a local board has certainly opened up my eyes to situations that arise, because things get brought a lot of times to the local board first. Realtors may not realize that we have this at the SCR level. Local realtors, really think of their local board as as the realtor board, and so a lot of times being on the board lets me hear different cases before they become cases. But basically, people will talk and say, "Hey, what about this? What about that?"
Super, excellent information. And then I kind of want to go through our South Carolina policy that we kind of run everything through. So we talked about, we have the statewide cooperative standards where we operate the Code of Ethics administration for the local boards. That enables us, we have lawyers on staff and a non-lawyer that's our administrator. We all take classes, we all stay current, we all do this every month so we don't get rusty. It's a removed back from the local AE, the local board. We have a bigger pool to pull people from for grievance committee and for hearings. I'm looking through here. We've talked about a lot of these things. We record the hearings for appeals with a transcript. Austin or Tierra. Austin's been doing it a long time. Tierra's starting to fill in as board counsel more often. So we'll all have a board counsel there to protect the association, keep the panel and the chair within guidelines so they don't accidentally violate any due process and get the association sued, and make sure that the process is being followed. Austin, when you see something kind of going off the rails in a hearing, what are some ways that you use to how do you get in touch with the chair and get the thing back on track? What are some techniques you use?
Sure. Can we take an executive session?
Yep, I hear that a lot.
It's there's one arrow in that quiver.
You can almost see when Austin's going to do it. Actually,
You really can. I watch his screen because you can really see when something makes him uncomfortable.
So, I mean, I guess we're talking about the number one trait for a professional standards chair, I would say, is being able to read the room.
Yeah.
And sometimes as the panel chair, you need to know that, hey, these folks need some leash. So maybe I need to put the gavel down for a few minutes and we just need to let them talk it out. And then there's some times where you're going to go, I need to pull that leash in. And you can tell sometimes where one side is just trying to run over the other side, and the other side is, they're not saying anything, but their eyes are, going, please, like, help me out here. And as a chair, you've got to kind of be aware enough to do that, or you've got to be aware enough to go, hey, I've got a panel member who looks like they're fading fast. So let's take a break.
Take a coffee break. Coffee break.
Let's take a comfort break. And you don't have to explain what you're doing. Executive session, just, hey, we need to take a 5-10 minute executive session. And the executive session could be for something as simple as someone's got to, get a cup of coffee. Someone needs to take a lap. Someone needs to, there's a phone call. Their phone has been on do not disturb, but they've seen that their spouse or their child has called them 8 times.
My kid's school is calling me. Yeah.
Like for the 8th time, like maybe I need to go get that, or, the parties are getting really hot at each other. We need to take a break, or we've just been going for 3 hours.
Yeah.
So that would be the number one trait I would say in a panel chair, is just the ability to observe,
Just monitor.
and then know when to pull the appropriate lever.
Yeah, we talked about our surveys. The number one survey item is, hey, there's unprofessionalism out in the marketplace. We want SCR to increase professionalism. So that's the whole point of all of this. We talked about, you see something, say something, file a complaint. You guys talked about when you talk to a client or an associate about filing. One thing everybody's nervous about, hey, if I file, they're going to, there's going to be retribution against me. Also, when people call up and they want to file anonymously, how do you explain or anonymous?
So we don't have an anonymous process. If you are solely wanting to file anonymously, you have to go through the Real Estate Commission. If you file anonymously with the Real Estate Commission, which you can, I always tell folks that your complaint better be bulletproof. Because if you file anonymously and there's one follow-up question the Real Estate Commission has, they don't know who to get in touch with, they dismiss the complaint. Our process, you have the right to face your accuser. So you can't file anonymously. You also can't file on behalf of a brokerage, because they need to know who in the brokerage is filing. You can't file on behalf of a board of directors. You can't file on behalf of a corporate entity. It's got to be actually a named individual. But our process is confidential. We do have in the Code of Ethics about, retaliatory and that type stuff. So if I filed a complaint against Mark and then Mark decided to go on Facebook and go, no one should work with Austin or trust Austin, he files ethics complaints on his own, we would have essentially a new ethics complaint for Mark.
We'd be filing one more.
Right. Yeah. And then at that point, that's going to be taken as you're not working our process. And so that's, again, when the panel would look at that second time and go, it's not getting through. Obviously, the first hearing didn't get through to Mark. Maybe we need to ratchet up the discipline the second time.
So council, does have the ability to let the panel know if this is a repeat offender, though.
After when?
What's that?
When do you learn that as a panel?
I don't even remember, actually.
Not to the end.
It is not until after.
Yeah.
Until after what?
After we've made our decision.
After you vote, correct.
Oh,
So we
okay.
do not
Yeah.
prejudice the jury pool.
Okay.
So we do not tell you until you've made a determination that there's a violation. Because if we tell you on the front end, you're gonna, maybe it's that one that's a 2-2 split and it's left for the chair to vote. They're going, well, if it's a tie, that person's already been in violation before. So that's where we do not. That information is not shared unless you make a vote in violation. If you make a vote not in violation, then obviously we're not going to tell you that.
So let's say that it is a repeat offender. We voted, found that they were violating Article 1. Now you tell us, council tells the panel that prior to deciding the penalty.
Yes, after
So the panel can use that as
part of your determination.
What the penalty determination will be.
Correct.
Yeah.
You've already decided that there's a violation, so we know for a fact they, at a minimum, we're going to get that $500 admin fee.
Yep.
As an additional element in determining, because the whole part of discipline is, how much knowledge was there? Was there malice aforethought? What was the, that type stuff. If you go, hey, this is the third time they've had an Article 1 complaint this year, that should be treated differently than this is somebody who's never had an Article 1 issue before.
I guess for panel members, if they're new to the panel, that's something that we talked a little bit earlier, what they can expect or what they should expect. But that is part of the executive session at the end. Is first it's a two-step process. Like first we say, yes, there's a violation, or no, there's not, and then then we decide what the determination is, what the penalty
Correct.
is. Yeah.
And you do not have the ability, and I know both of you have been on panels where you can't find someone in violation and say, we want to find them non-violation, but we want to essentially issue them a letter of caution of here's what you can do instead. If you find them non-violation, you can't get disciplined and be found non-violation. So if they're non-violation, you can certainly write the findings of fact in a certain way. It can't be accusatory or anything like that, but there's no ability to say, hey, you weren't in violation, but you were this close, or you got by on a technicality or anything like that.
Yeah, and it's based on due process, right? We don't, the reason the board counsel withholds that when you're voting on a violation or no violation, we don't want it prejudicial, right? Because we could prejudice, it's like putting a thumb on the scale of justice. So, but as we talked about in the Code of Ethics Arbitration Manual under disciplinary guidelines on page 68, it talks about guidelines for first violations and repeat violations. Because if somebody repeat violation, they get typically the hearing panel is going to give them a little bit more discipline to make sure, because the goal is to get them back up to a professional standards level. And then looking at the policy, thankfully we haven't gotten to this level of offenses yet, but we can actually, the LLR publisher, there's a permanent record online on the internet, so you never want that because somebody Googles your name and your name pops up as an LLR violator of license law. That's not going to help your business. So that's why we keep everything confidential. But if somebody's an egregious violator, we talked about fines. Fines can go up to $15,000, but if you get a $10,000 fine or your membership suspended or you're expelled from membership because of what you did ethically, we can publish that. We can publish the photo of the violator, the violator's name, and then the articles that they violated.
How many times has that happened?
Thankfully, not yet.
And that would only be an internal publication that would be behind our realtor firewall. So that would still not be public facing.
Yeah.
And sharing that behind the firewall, public facing could potentially be an issue for you. So
yeah, don't do it. That's a bad thing. And then also public trust. If there's a violation that violates the public trust, that's kind of fair housing discrimination or fraud that causes financial harm. The association has to turn that over to the authorities, to LLR, the Human Affairs Commission. So that's in the policy. Let's see, looking out.
So in theory, at that point, the person could be found a code of ethics, and then SCR has to at that point turn that over because it's a matter of public trust.
It would be a vote of the board of directors. It's not an automatic. The board of directors can choose to do that.
Okay.
Yeah.
One thing that comes up in executive session, and it comes up on the board of directors executive when they're ratifying, there's been concern saying, hey, in the old days, we used to say, you can't use this for a designation. You can't use this for continuing education. And anyone said, hey, you guys can't do that. It was difficult for us to track. So now we don't do that. Austin, when a hearing panel is discussing that, what are some things that you informed the hearing panel in executive session about them double dipping on CE?
Yes, we have no ability to work with LR and say these hours can't count. So there's no ability to do that. What we tell the panels when you determine discipline as a panel, you can't tell them you have to take this particular class by this instructor. Generally, it has to be a topic area, agency, ethics, contracts, disclosure, whatever it may be. But you as a panel get to determine the topic of the course, the number of hours for the course, when the course must be taken, and whether it has to be live in person or if you can take it online. So even though those hours may be able to be used for CE, you can say, yeah, but you were planning on doing your CE hour. You just renewed in June. You weren't planning on taking your hours for another year. Well, nope, you got to now take all your hours within 90 days, and you don't get to use it. You don't get to take it for a designation. You don't get to take designation class. You got to go take 4 hours on disclosure or 4 hours on agency, and it can be a combination. You could say, hey, we want 2 hours of ethics, 4 hours of contracts, 2 hours of agency, and now we're going to have a 10-hour discipline there.
And then another thing that comes up, Austin, say somebody's found in violation, they go, I'm just going to drop my membership and they can't touch me. Talk about what happens when somebody drops their membership, try to evade discipline under ethics.
Yeah, so that discipline at that point essentially becomes like a sword of Damocles over your head. You're correct. If you're not a member, we do not have any ability to enforce discipline on you, but it essentially gets put on your file. And if you try to rejoin with SCR or any other realtor organization in the country, there would essentially be a ping on the file that says, hey, this person's got outstanding discipline from SCR at that point.
All right, so that kind of wraps up kind of my interview notes. Gentlemen, kind of closing thoughts. What are some issues that you'd like to talk about? Any questions for us?
How many people sit on professional standards?
Well, we get 5 per local board, so I don't have an exact number. Austin, you got to it's a long number. I've seen this spreadsheet.
It's about the roster is probably 80 to 100 for each committee.
And we welcome volunteers. That's a good point because a lot of people will get on the committees. We do an orientation every year, but you might not get called. So people are like, oh my gosh, was I even on that committee? So that's one thing we're going to try to work better to try to integrate and educate. Alan Lightley's our staff liaison to the Leadership Academy. We've got a couple of those participants that are interested in serving on grievance and professional standards. So we're going to generate some video with them in the leadership class, some mock hearings, mock grievance committee, mock professional standards committee, trying to recruit folks in and also try to educate because we're at that point now where we need to try to create people coming up to replace us, right? Because we're all going to retire someday. Bringing in people and getting them ready.
That's just the point of the serving aspect of this professional standards and grievance. Finding my replacement. Finding my replacement. And having other people want to be part of the process. Finding those people who are passionate about it. And if y'all are watching this video, again, I'm not to speak for James, but I mean, for me, giving back this way has been really, really good for my business. Just in general, it's made me a better broker. It's made me a better realtor. Just watching this process and being part of the process.
It's for sure made me a better broker and a better broker in charge by far.
Yeah.
Being able to see some of this and learn do's and don'ts and of things that you wouldn't think of.
Yeah, it's helped me learn things that I wouldn't just have learned from reading license law.
Right.
Yeah.
Definitely. And then I know you guys wanted to speak directly to we'll use this video also with the grievance committee, like say somebody's going to sit on the grievance. Lindsay Pittman's going to send them all the documents. It's also, she's going to send them a short video from you guys. So please, what would you say to a grievance committee? Say Austin and I are going to be on a grievance committee. What would you say to us? What are some things, some words of wisdom you would tell the grievance committee?
Make sure you read everything the night before. Make sure you understand the code of ethics and specifically what that particular case is looking at. And make sure you read the standards of practice. Be the big thing. And make sure you come prepared. Quiet, like we talked about. No kids running around. No pets running around. Make sure you aren't wearing your company insignia and stuff like that.
And when you're chair of grievance and say Austin and I are on the grievance committee, and we start trying the case. We're like, well, I don't think this, I think this, and start arguing for the respondent. How do you rein us back in? Because that's really not our purpose on the grievance committee. What do you remind us?
Just remind, especially if you're trying to defend the respondent, I just continually remind that we're looking at it on the face of it. If this is true, would this be something that's in a professional standards? We're not here to try the case. We're here to kind of be the gatekeeper and say this could be a violation, and if so, it needs to be moved on. We don't decide the case, and we're not going to know what happens with the case. When we walk away from this, we shred everything, and we have no idea what happens from here.
Super. Yeah, and Mark, same question. What advice would you say? We're your grievance committee hearing panel. What would you want to say to us before we convene on the Zoom?
Listen to your other panel members. Listen to what they're saying. Listen to what they've noticed that you didn't notice, maybe. That's kind of the big things I think that are different than what James said.
And I would say try to come with at least one question. I always try to write down a question too, just to have something in it.
Somebody's got to start the dialogue, right? Somebody has to start the dialogue on the panel when they start talking. Somebody has to be there to do it. And for grievance, the respondent's not there, the complainant's not there, so it really is just five realtors on the panel with the attorney to talk it through.
And then when Lindsay Pittman sends you the grievance committee checklist, is that a great tool for you as chair when you're on grievance?
It is, and even if I'm not chair, back when I was just a panelist, I would print one of those for everyone and fill it out, just so I had I could answer the questions in case Mark was chairing and Mark said, James, who's the respondent here? I had my cheat sheet, but that made sure that I had learned the case before I got into that day. So that checklist is very helpful.
And Austin, when you're board counsel for grievance committee, kind of same question. What do you see as some things you would say to the grievance committee before they start? What's kind of your words of wisdom to grievance committee members that are watching this video in the future?
Just remember your role, that it's to not to try the case, but to take the complaint on its face as true. Does it meet essentially the three questions? Is it against somebody that we have jurisdiction over? Is it against a real estate member? Was it timely filed? And so what? Assuming everything is true, does that match with the code of ethics? If you get 3 yeses, then it moves forward. If there's any no, then it probably doesn't. And then, like I said, just reading the material ahead of time that's 99% of the battle.
And ask questions. I mean, you're going to have Lindsay Pittman, the administrator, on the Zoom. You're going to have most likely probably Tira is doing a lot of this now. So you're going to have Tira Pitts, attorney at law, on there. Feel free to use staff to ask questions. It's there's no harm in, if you don't understand something, asking questions. And then switching gears for a professional standards hearing, for either an ethics hearing or an arbitration. For future viewers, what would you say? Say Austin and I are going to be on your hearing panel for an ethics or arbitration, and you're the chair. What are some words of wisdom?
Hey,
for us?
don't go look up stuff in advance. don't research the case outside of what's been provided to you by SCR, by Lindsay. Dress professional for the event, for the hearing.
But make sure you do research the case, because in that case,
the only research you're doing
is
you're actually reading the hearing. That's the research.
Yeah.
Like reading the hearing all the way through, reading the complaint, reading the response, matching it to the code of ethics.
Yep.
And same question for you, James. You're chair of ethics or arbitration, and Austin and I are on your hearing panel. What are some words of wisdom you're going to impart to us before? What's some key
come
issues?
open-minded. Don't come with a predetermined decision, mostly because it normally doesn't go that way. But come with questions and make sure you understand the case. Don't forget about it until the morning of, and then get there and just be like, oh, okay, I think this is about this, and make sure you understand the case a little bit.
And Austin, when you've been board counsel for many years, what's some words of wisdom to the future ethics or arbitration hearing panels out there that are watching this video?
As I think Mark mentioned earlier in this video, take your day off. The shortest hearing we've ever had that I've been a member of a panel or board counsel on is 37 minutes. And that's pretty much how long it takes to read everything. Because in that case, no one said anything. Both the complainant and respondent waived their opening and closing statements and their case in chief. So it took 37 minutes to just get through the dance. And the longest is about 7.5 hours. So, and there's no way to tell. The one that went 37 minutes, I thought was going to take 7 hours. The one that took 7 hours, I thought would take about 2. So block off your whole day. That would be probably the number one piece of advice. And then the second would be, don't forget what the hearing is about, that it's about the articles alleged. So being able to see the forest from the trees. A lot of times these cases hinge on a very small detail. It hinges on when a document was signed, when a document was presented. You'll be presented 80 documents and there's only one that matters. And there's only one date on that one document that matters. So being able to because parties will throw stuff out there either to try to confuse you or because they don't know any better. But being able to sort of filter through all that and get to the case that is actually in front of you, not some of the other outside matters.
Excellent. And if you need a lawyer, the South Carolina Bar Association has a lawyer referral service. You can contact Austin, Tira, and I all work for the association. So we're looking out for the association. We're keeping for the lawyer there for the board counsel and for the, for the hearing panel and the chair. But if you're a complainant or respondent, you can come to these hearings without a lawyer, and that's probably the majority, but lawyers often help. They keep the discussion on track and focused. But you can ask your attorney friends for referrals if they can help you, or contact the South Carolina Bar if you need legal services for an arbitration or a mediation or an ethics hearing. That kind of wraps up the shorts. We'll kind of go around the room one last time. Any kind of closing thoughts, Mark?
No, aside from just, being part of this process has just been good for me in my professional development. So being part of professional standards hearings, being part of grievance hearings, has just helped my professional development, helped me be a better realtor, better broker in charge, better real estate instructor.
Super. That's excellent. That's good recruiting words of wisdom, trying to get people to join, because a lot of the tools cross over, right, in your family life or in your professional life. The skills you learn when you're on the hearing panel and seeing how human beings operate under stress.
Taking mediation training, becoming a mediator, just even taking the training itself, helps you rethink and refocus how people communicate. Real estate's relationships.
Yep.
That's all this is relationships. It's your relationship with your broker in charge. It's your relationship with the customer or the client, your buyer, your seller, and with your colleagues. And so that's all this is just relationships.
Super. James, same question.
I would echo everything he said. And then I would also say, if you're actually watching this, you should sign up to be on the committee, because if you're watching any of this, that means you have some interest in making
If you made it
this profession
far.
better. So, you should sign up. It would be worth it. It's definitely giving back, and it's not a lot of work. And you do learn ways to not get in trouble by doing it.
Yeah, that Zoom, we don't have to travel anymore, because that would happen. A lot of people would travel, and then the case would get continued. Somebody gets sick or something like that, or somebody lives far away. So the Zooms help a lot. There's no travel. By and large, there's no travel involved. Minimal time, because you talk about how we've got basically a kind of a jury pool. We've got a large grievance committee, a large professional standards committee, and we select. And if you're interested in being active, just let Lindsay Pittman know. She'll definitely put you on hearings. We can even add you as an alternate so you can view some hearings, because this is all confidential, but as an alternate, you'd be able to view the hearing. Obviously, executive session, you're going to leave at that point. Austin, closing thoughts from your point of view as board counsel.
I just want to thank Mark and James for their time today and their leadership in the association on these committees. And to anyone who's been watching this, we look forward to seeing you as a panel member on one of our hearings. So,
On that joke, we'll shut it down. So thanks for viewing. Please sign up for the committees, and thanks everybody for participating in your service.
Thank you, brother. Yeah, thank y'all.
yeah.